Okay, today is day 3. Approaches for preventing and resolving vilification for self, colleagues, clients and patients. This workshop aims to work with yourself, colleagues, students, patients and families. And you saw yesterday there is a big impact on the family unit, and that your relationship with your partners and even with yourself. The effect on yourself and your relationship with self is very, very big. By the end of today, we aim to provide you with an understanding of the following: the difference between administrative law, civil law, and criminal law regarding vilification. Your legal and ethical rights when protecting your reputation after vilification. So if you have been vilified, what can you do about it? And is it worth doing anything about it? What is available to you? And we've learnt a lot. We came through a period where there was nothing in place for internet defamation, nothing in place really for people who set up fraudulent structures and portray themselves as long-term well-regarded entities. And we also got a chance to have a look at the legal system as it started going into the throes of coping with vilification from the perspective of the internet and social media. And it has still not caught up. The legislation has not caught up. And the problem is that if something happens to you personally today in this world, if you have an event like you may be being investigated, somebody has vilified you, before in our analog world, you could actually isolate that off, pick yourself up, go start a new life, a new career somewhere else, and that situation was left as it should be, alone. You could move from the environment. In today's world, in the digital world, there is no escaping anything, and you need to develop a very strong understanding of how to cope with that social media, that internet world. I spent a lot of time today talking to you about what to put in place, both as a safety net in case something happens, but secondly, if something has happened, what to put into place to mitigate the damage, all right, and to help ameliorate it, bring it down to something handleable. Okay. Tools to prevent or counter vilification in newspapers, reality TV, social media, internet, or by deliberate destructive gossip. You know, you can see that years ago, we're going back as far as 1997 and before 1993, I already had a very strong view on gossip and communication by that document I put together and put out to staff. I was already in the throes of dealing with that within my own companies and businesses. So I've had a long-term view regarding this. But the thing that I find most difficult to ratify, and I still don't, and I don't believe it's been addressed, is unethical journalism. Unethical journalism on every level. Sensationalist journalism, I don't believe has a place. I don't believe that sensationalism and unethical journalism has any place in today's world. We've got a world that's very global. We have a world where we have third world countries and second world countries attempting to follow our model of lifestyle and our functionality. And in my mind, there is no room for people in that position of power to not have an ethical base. And if there's a group of people that I think needs to be reined in, and if there's a group of people that need to be made accountable and criminally accountable, it's journalists that are unethical. Yeah, ethical journalists, I bow down to them. Investigative journalists that put forward a true and total story, I have no issue with. And I don't even care what the outcome is of those stories, so long as it's true. But unethical journalism does a lot of damage in this country. And our media, and the media in general, those two major conglomerates have too much power. We really have an oligopoly, nearly a monopoly, because they deal with each other socially. They go to each other's parties, they live in each other's pockets, they're not even independent of each other. So it's, you know, how are we getting neutral journalism? Problem is that when something happens for you guys in your personal lives and one of these people get hold of it, it's not told the way it is. Yeah. And I think that there is room for a new search engine to come about that is maintaining things ethically, and to get away from your Googles, your Yahoos, and all the others that are existing at the moment, and for an ethical search engine to step up would be very, very relevant. And there's other things going on within social media, and Mildred can tell you a little bit about that. The individuals that have originally backed Google and many of these other large corporations for freedom of information and putting the facts out there, a lot of those individuals now are all backpedaling because they're keeping their data on them, they're keeping information on. They become the new big brother, but it's a corporation, it's not even our government. So we go on. Services that could aid you, your colleagues or clients to resolve vilification. Approaches for preventing or resolving vilification, self, colleagues, clients, patients. Resolving vilification, this is really important for today. You really need to get a handle on this and accept this. Resolving vilification does not provide legal advice. What we are providing is a guide only and designed to make you aware of possible options related to the topic of vilification. The information provided is designed to inform you of relevant procedures and protocols so that you have an understanding of vilification events and processes when you either witness them occurring or they are being described to you by clients, colleagues, friends, or family. You need to have an understanding of what people are talking about. Sometimes we sit in our practice rooms and we've got a client describing something and we really don't understand what they mean. And when someone's being vilified, the worst thing you can really do for their mental state is interrogate them. Oh, could you please explain this to me? Oh, could you please explain that? Go back a bit. What do you mean? What are you talking about? You've actually got to have enough background knowledge to be able to flow with their story. And at the end of it, maybe ask a couple of very pertinent points, but you really can't ask a lot of questions. People who are in the first throes of coming to you for help, and yourselves included, okay, the thought of being interrogated is 90% of the reason why you don't step up and go to anybody for help in the first place. Okay, and it's not the interrogation per se, it's the sense that you have to justify who you are, why, and you have to back your story up. And it's very, very daunting to do that. So you need to have an understanding of some of these processes in the background. We had somebody on one of our other workshops who was describing some horrific situations at work. And I was in a different state, so I really didn't understand that particular state's ins and outs. But I knew enough about my own state and 2 other states that while that person was talking, I could keep up, but then I could go back to the relevant bits I didn't know and go, could you just explain this bit so that I could capture where I was at? Yep. The information is to make you conversant in procedures and protocols, but not an expert. The aim of this workshop is so you can follow the right pathways and know what is waiting for you at each juncture. The information provided in this workshop is not exhaustive. Administrative and civil and criminal laws change quickly and regularly. Thus, any information discussed here must be checked with your legal representative before acting on it, or go and read it up yourself. Okay, it changes fast, guys. What's here 1 minute is gone the next. So what is relevant today and what people can do today may not be the case tomorrow. Please ensure that you confirm any decisions and risks with your legal representative at all times. And we will explain to you, quite often even your legal representative is not up with the new changes. Can I say, do not think that when you're paying that legal person that they know. It's up to you to double check them. And I experienced last September a situation where I've never thought in a million years that a judge would accuse me of being the incompetent one, and that I should have known when my legal representative was paid to know and to make sure it was done right. How would I, with everything else going on, working full-time, have the time to do that? But that was actually the judge's attitude. You're a professional woman. You should have known. It was up to you to know. You can't blame anyone else, which I wasn't blaming anyone, but the process of that was so clever to shift that away from anybody in the legal system being responsible, when in fact they all were. But all that I'm saying is be careful. They know how to shuffle. They're really good and they're your best friend. And some of you will have good representatives who are genuine people and altruistic in their approach, but others, okay, so you've got to really shake it out and don't be ashamed to move on, go somewhere else, find someone new and double check. We actually ended up in a situation, our very, very good solicitor recommended the solicitor that did this to us, okay? Our very, very good solicitor. And he's just absolutely shocked and he's so upset. He couldn't do any more because he was beyond his capacity to cope and it wasn't his area of expertise. So then when he moved us on, he assumed he had gone to a better source. So then again, even they themselves don't know sometimes. Workbook 1, we're just going to cover your homework. And what I'm going to do, just before we go to the Peter Principle homework show, I'm just going to jump forward one. And I just want to quickly talk to you about Peter Principle. Lawrence J. Peter, 1969 and 2011, he has an updated book. The original one was 1969. established the term Peter principle. The Peter principle is a special case of ubiquitous observation. Anything that works will be used in progressively more challenging applications until it fails. This is the generalized Peter principle. There is much temptation to use what has worked before, even when it may exceed its effective scope. And Lawrence J. Peter observed this about humans. So somebody who was really good in that position and really good at that, because they were so good at it, we should move them somewhere else to see how great they are here. So you move them to the place from where they're brilliant. You put them to the new place and you expect them to be brilliant there, and their Peter principle has been hit. They actually can't progress from that spot to the next, okay? And that's where a lot of your vilifiers are. It is people who are scrambling to hold a position that they can't manage, they can't maintain, they're not good leaders, they don't actually understand human nature well enough to be a team leader, okay? They can't move through the different personality types to be successful at it, and they don't understand human nature well enough to understand what you hold on to and what you let go of. So that Peter principle is what he's talking about. It worked really well here. Now let's put it here because it's got to be able to work well there, okay? In an organisational structure, assessing an employee's potential for a promotion is often based on their performance in the current job. This eventually results in their being promoted to their highest level of competence and potentially then to a role in which they are not competent, referred to as their level of incompetence. The employee has no chance of further promotion, thus reaching their career ceiling in an organisation. Peter suggests that in time, every post tends to be occupied by an employee who is incompetent to carry out its duties. And that work is accomplished by those employees who have not yet reached their level of incompetence. You see this in the armed forces. You see this in the public service. You see it in large corporations as well. So, for instance, in the armed forces, you'll have somebody there, they're incompetent in that role. What they'll do is they'll move them sideways or they'll move them up. But they never move them down or back to their level of competence, because to move them back or down to that level of competence means a loss in status and a loss in income, okay? The clever way to handle this is, put them back to where they were. They probably weren't being paid enough anyway for that brilliant job they were doing there. Leave them on the same pay packet. But put them back to a place of competence, and our system doesn't allow it. And the individual has been shifted from there to here goes, no way. No way are you going to demote me, and no way are you going to move me there. And I'm not going to take a pay drop. He noted that their incompetence may be because the required skills are different, but not more difficult. For example, an excellent engineer may be a poor manager because they do not have the interpersonal skills necessary to lead a team. So getting back to doing practical work in engineering, you move them up, they make a bigger mess. All right, they're more incompetent, they get more frustrated, and they require the team underneath them to carry their load. Quite often you'll have an incompetent team leader, and what the rest of the team will be saying is, I can't take on any more responsibility. I can't take on any more of that work. I'm already working his job and that job. And what they do is they come down and they delegate their work out. Right? Absolutely. Yeah. Peter principle and vilification. Rather than seeking to promote a talented, super competent junior employee, Peter suggested that an incompetent manager may set them up to fail or dismiss them because they are likely to violate the first commandment of hierarchical life with incompetent leadership, namely that the hierarchy must be preserved. Okay, and as I said, we were talking about academic institutions. Yeah, all those old boys that are sitting there are at their Peter principle. You only have to go into their offices and watch them scrambling with all the red tape, but they're not going to bring a junior in because that junior will figure it out that they are incompetent and they may not hold their position. But secondly, if I bring them in and teach them, they will get my position. Yeah, it's very obvious to me in those institutions. I see it all. Anyway, so Peter principle and bullying. And what we did is that first article in your homework. Oh, my folder is in the black thing. Does anybody want to comment on that? Just grabbing out that very first reading, Peter principle and bullying. Oh, sorry, that's my fault. Grab it.
Just very briefly, about 10 years ago, I was looking over university in psychology, and I noted that there was so much amazing intellectual property that was coming out of research that would have very good application in the field.
Yep.
Take these incredible theories and whatever and apply them. So I went to the school, there was what's it called there? I can't remember. It was a department set up within the university. It was about commercialising intellectual property.
Yep.
So when I went and said, hey, look, there's this, that, and the other going over there. Let's take some of those things and, commercial. And he said, yeah, great idea. So he worked with me, the head of school, to sit down and have a meeting about how to, implement this kind of enterprise. And she just shut me down. I got this email, it was referred back, so how dare you do that? How dare you? I was totally horrified. And it was, and then this whole thing that came at me was, our school was about research for research's sake only. There was no place for commercialising. It was just that it was that. It was that. But anyway, that's cool.
Don't worry. Well, she was just describing being in a university setting, going up with all the research and stating clearly to them, hey, let's get this and commercialise it. There's so much here and there's so much intellectual property that we've learned. Let's do something with it. And the powers to be came back and said, well, we're not here. We're just here for research's sake. We're not here to commercialise. And so that concept, and a lot of research is just lost like that. And it's sadly lost. Look, keep that Peter principle in place too. They were talking just recently about the Greens, how they do this transition from one leader to the new leader in this really nice way where the old leader comes in, introduces the new leader. They've sat down, they've had a collaborative discussion. They've made the decision that this is the best person for the job right now. And they stay there till they reach their level of incompetence. And I was reading an article how people were laughing about the fact that the Greens do it this way, but they're actually making sure that this doesn't happen. It's not all lovey-dovey and perfect and everything in the background, but they're going, hey, I can't lead at this point anymore. There's things that I can't do at this point. Who's going to take over? And so in comes the new leader. And you see them all truly just supporting the new leader. And, I'm sure that they've got their own factional, but at least what they're doing, is the way it should be. You have a new leader. Why do we have to have this big caucus drama and this big media hiatus and everything stops while they decide what they're going to do? What we're going to do is we're going to start on administrative, civil and criminal law. Administrative law. Administrative law is the body of law that regulates government decision making. Administrative law is an area of law that you will need to rely on if you wish to challenge a decision or action of a government official, department or authority. For example, APRA. Criminal law. Criminal law is in place to maintain social order and is enforced by the police. Penalties range from fines to jail time. You can report abuse, stalking, harassment, etc. to the police and attempt to have a person charged as a deterrent to them, continuing the negative behaviour. However, if you wish to obtain compensation for damages, then this must be achieved under civil law. Civil law. This covers the rights and duties of citizens to one another. You may sue someone else if you believe they have broken a civil law towards you. Civil law cases include defamation, discrimination, and breaches of contract. Now, the other thing that I need to mention at this point is within criminal law, there are defamation laws, and our law system can charge, fine, and jail people for defamation. They choose not to enact it, And when you look at the case of my case, for instance, I believe that sits in the realm of criminal activity. There is no way that that's just something happening amongst the civil situation amongst a few people or one person being inappropriate towards you, which is usually the realm of what defamation is. So like, for instance, if you go into a business meeting and you're at a board meeting, let's say, and it's a corporation and you're sitting in the boardroom and one of the directors stands up and says, well, you know what? You are a so-and-so and so-and-so, and sits back down. That person can stand up and say, you just defamed me, I can sue you. How dare you say that? Retract the statement, I demand a written apology. That person chooses not to retract the statement and won't give an apology. That person can then sue them for defamation. Because it's as simple as that.
Unless it's based on fact.
That's right, unless it's the truth. If it's the truth, it can't even just be based on fact either. It has to be the truth. Then obviously there's no defamation that will pass. They can sue him, but it'll fall over in court. Yeah. So what I'm trying to say is I can understand that as being an issue that should be dealt with within the civil law system. But if you ever, don't have to do it, for goodness sakes, don't ever do it. But if you spent the time and you went through and had a look at what was on the internet and saw what had actually happened to myself and my family, you will see that this was premeditated, pre-designed, there was a definitive outcome, and it was really premeditated defamation, which is no different to premeditated murder. And the thing with defamation is that it kills every aspect of you except that you're walking around and you're alive, okay? You have no credibility, you have no future, you have no career, you have nowhere you can go. That's what it can do. And if it's not true, why are they not being charged? We've given them all the information. It hasn't happened. And I'm not going to get into it. Their argument is that robberies, rapes, murders, etc. all come before they get to that. Same goes with, we reported theft. What do you call it? The theft that happened in a bar. The theft. No, the theft with all the money, embezzlement.
Oh, the embezzlement.
The embezzlement. We reported embezzlement and gave them all the evidence on embezzlement. Everything. But it's sitting there waiting for when they've got time to get to it. And because it's got a 5-year statute, they don't have to really act to the last minute of that 5 years.
Who's the they you're referring to?
Police.
Oh, okay.
Criminal law.
Okay.
Okay? So they is the police. So what I'm getting at is you need to really be aware that when you go lean on that criminal system for help, it's not necessarily going to be there. Okay? And then I'll give you stories about the police that spoke to me about a number of other things where they themselves ended up being defamed and what they then did, and how limited their capacity was to use the defamation laws. They themselves wanted to at one point. And the best that they could get was public nuisance. Okay, that was as far as they could push it amongst themselves. So it's not legislation that anybody is really utilising very well. The following are examples of the range of administrative decisions that may be challenged using administrative law principles and mechanisms. To impose conditions on a licence, that a person is not fit and proper to hold a licence, by a council to compulsorily acquire land, by a minister not to grant a visa, and of Centrelink to cease paying a benefit. Okay? So the following are examples of a range of administrative decisions that may be challenged using administrative law principles and mechanisms. So any one of these bodies, so you need to be able to deal with them through their administrative law. And then you need to get a lawyer that specialises in that. The following are examples of decisions that may not be governed by administrative law. Legislative decisions, example, the making of laws. Broad policy decisions, deciding to reduce a grants program. Employment decisions, decisions to hire an employee. However, administrative laws may apply to public service misconduct decisions. Criminal cases, decisions to prosecute. However, administrative law does apply to investigations. And contract decisions, decisions by government to enter into a contract. However, tender processes may be subject to some administrative law principles and social life. And I think one of you guys spoke about somebody that they were made comment about her private life. There's no way that any of this is available to you. You cannot comment on someone's social life and how they live their lives away from the system. All right. So what am I getting at here? Be aware that administrative law is created in some ways, yeah, by these factors here. Yes? So these are the things that create your administrative law.
Can you comment on someone's personality? Say that someone has passive-aggressive personality.
At work or at work, you'd have to go through your HR, and if they're affecting you at work, you would go to somebody, you would lodge a complaint with your HR, and then you get a caseworker who would then give you a hand with what you can and can't do within that structure. That's my belief. You can't just walk up to someone and just go, well, you know what, you're not suited to the job. I don't think you've got the right personality, because it's so subjective. Like that they may have gotten the job or have that position exactly for having those characteristics. So we don't even know what they were looking for at that time. Yeah. Yeah.
Just on that, a good friend of mine is a lawyer, and he's always said to me, let the facts speak for themselves. There's no need to summarise or pass, comment or judgment on the facts. So if someone is passive aggressive, it's just like outline the examples, the facts of what is the passive aggressive rather than the interpretation of. So
yeah, you list what the evidence is that your problem is. You have a problem, this is concerning me, code of conduct, whatever it may be, and this is what I have witnessed.
Don't bother about interpreting that, because the facts will speak for themselves.
There are four main types of review of administrative decisions. One, reconsideration by the original decision maker. Two, a specific statutory right to review the decision on the merits, internally or by a tribunal, such as the Victorian Civil Administrative Tribunal. Three, judicial review by a court, or complaint to a body such as the relevant ombudsman. So you've got four areas that you can go to get administrative decisions reviewed, changed. You can even have them revoked, or you can even have the ombudsman say, well, yes, this needs to be looked into, but the ombudsman, will see this in a while, doesn't actually undo the decision. Okay, so you've got to have a look at what we're trying to achieve. The administrative law is very different to other laws. Challenging, and when people put in a false complaint, you are dealing with administrative law. Whether that false complaint goes to APRA, whether that false complaint goes to the APS, whether that false complaint goes to your employer, yeah, you will immediately be dealing with administrative law. All right? One, reconsideration by the original decision maker. Always consider this option first, subject to any time limits that might restrict other forms of review or litigation. As long as the original decision maker has not exhausted their power, they may be able to reconsider their decision. If you are not sure, you may ask the decision maker whether they are prepared to reconsider the matter. So you go to them and you ask, I'm not happy with what's come out of this. What can we do about it? And find someone to converse with. Always find a name and a person. Don't ring into a switchboard and just go blah, blah, blah. If you do ring into a switchboard, find out who you spoke to and ask, can I call you back if I need to know more? All right? Always have an individual that knows you, because what they will do is they will give you the facts. They'll tell you exactly what's there. They'll be able to quote it. And even though they may not necessarily be that warm towards you, they will always give you the black and white truth. Okay, so you want to find someone who, and if within their job description it says you must be helpful, then they will be helpful, but in a very methodical fashion. So search out those people that will just keep giving you those facts. But if somebody blows you off, isn't helpful, bring back. I've done that previously where we've had situations that we know need to be addressed, and we get 1, 2, 3, 4 people that are just awful to us. Then eventually you get one, find their name out and keep calling back, because they will know that that other 4 shouldn't have been doing that.
The important bit on that is also to get their actual personal email address.
You're going to need to speak louder and towards there, so you might have to get up and go there.
I was going to say, just when you're communicating, you do find that person, get their personal email address, because usually they have their general email addresses for complaints and communicating with. When you do finally find them, ask them for their personal one, so you can keep just going back to them. Because like Natasha said, when we finally did find somebody, then I was able to communicate just directly with them backwards and forwards, and you get a lot quicker answer, and they knew who you were, and things like that.
And the other thing is that they will eventually give you the time to tell your story. And they eventually, if you don't get to hear what your story is from you, they in the end stick you in the file, and they will get to know your story, and they're more likely to help you. All right? So you want to find rapport. You can't go into these structures expecting that the rapport is going to happen from their end. There is no therapeutic alliance with you. They do not want you to call. They don't want you on their plate. They don't want the hassle of doing it. So you have to figure out how you're going to build the rapport and build it with someone. Okay? Put your tentacles out and don't feel shy about it. I think it was the second complaint that was put into me about me in the Queensland board. It would that was a very, very wrong situation what occurred there. But that second complaint that went ahead, in the end, I found one person that I rang and I spoke to, and each time I spoke to him, he notated everything that I said. And when I went to this tribunal that I went to, he had written it all down and gave it to me in a report that he had given to each of those people on the table, every single word that I had said in that conversation. The fact was that he had actually helped me inadvertently. And he was the one that when I read the complaint, I read it and I went, what am I going to do about this? There's no way in a tribunal that's going to last 90 minutes that I am going to be able to get across to them the level of injustice and the number of injustices that have just occurred by this complaint going in. And he was very quiet. He sat there and he goes, well, procedurally, if you wish, you can make the choice. I remember his voice is clear as anything. You can make the choice to write it all in a written format, and you can take it sentence by sentence and reply to each sentence if you should choose that you would like to do that. And I just remember thinking, right, that's what I'm going to have to do. And I said to him, okay, well, if I write that, what happens with it? He goes, well, it gets presented to the people in the tribunal and they must read it before you walk in. But most people aren't aware of that. They're not aware that you can actually do a written reply to the complaint and pull the complaint apart with your evidence in that written reply. Okay? And at that time, it was definitely not common knowledge. And in the end, that's probably what saved me in that particular tribunal.
Because the Fair Work Tribunal works that way.
Mm.
Yeah, you can do that there. But often the arbitrator won't read.
No, they won't. But then
at least you've got the avenue to.
That means that if they don't read and they come up with the wrong decision, you can then write a reply or get to go back. But they don't make it common knowledge. A lot of these things they'll say to you, go read the legislation. And I've had people say that to me. Well, yes, the answer is there. Go read the legislation. And you go, no, hang on. I'm reading here. This is supposed to be a helpline. Go read it. Bang. Okay. So you're left out there. So you need to negotiate your way through administrative law, and you need to be aware. Make sure you get the most recent one and make the phone call. You have the most recent legislation in front of you. It's not always updated on the internet as quickly as it should be. It's not always done, so always double check, because they say to you, if you get it wrong, that's your fault. The onus is on you to get it right. It's not our responsibility to help you. So you really are on your own under the banner of administrative law.
And so to find the most recent legislation, is it Ausly or is it like just type in, Fair Work?
We've got all the.
You've got it.
What the web pages will come up.
Yeah, but also on their actual web pages.
I remember looking for legislation, including in law journals, and it was extremely vague and difficult to find.
Yeah. Ausly is the good one to look at, but also just to point out, when you go to the websites for each organisation, you can always scroll down to the bottom of that page where they're talking about their legislation and see the date they posted it, because they have to do that with the local government. They'll always have it when the date of the actual legislation they take it from and when it was posted, so you can see how many years ago it was, and that'll give you an idea of how recent it is as well.
But didn't Natasha just say that often it's not?
Yeah, so that'll give you an idea though. It's just another sort of bit of information to help you.
But cross-check it, so it was or something.
I would ring.
Yeah.
You read it, you just go, I've seen this has been posted on such and such a date. Is there anything new since? All right, I double check everything.
Yeah.
And also on those sites like APRA, sometimes if you use their search box and you type in the search terms of what you're looking for, you'll see a lot of the discussion papers that are happening come up in the search results that are actually happening more recently. So that way you can get an idea to see if it has changed yet or not, or if it's what's in discussion about that. Yeah.
Okay, generally speaking, if more than one person's rights are at stake, reconsideration may be possible. Yep.
May not be.
Pardon?
May not be.
May not be. Did I say may?
Yeah.
I did that last time. May not be
Yeah.
possible. Okay. Example. For an APRA complaint investigation, if you are not satisfied with APRA's decision, you can write to the complaints officer within 30 days of the decision and request a review. The complaint may then be referred to the Chief Executive Officer of APRA for internal review. Remember something though, guys, every time it climbs a level and it goes higher, that means that if you get a finding that you don't like or isn't what should be the finding, you have less and less chance of it having it reversed. So what will happen is if it's a complex situation, your case manager or the people of the level that it's at may even refer it up without you being aware. And then you'll think, oh, great, they've taken it up to so-and-so. But the idea is the higher up they push it, the quicker they can get it out of the office. So don't look at the being pushed up higher or you pushing it up higher as necessarily being the thing that's going to give you the right, in inverted commas, outcome. Okay, because we're just experiencing this now with the Australian Press Council, which I will get to in a little while, with the last lot of completely unethical journalism that occurred, not just with one newspaper corporation, but two different ones. And they are now, what they're doing is they're pushing it up line. And as they push it up line, what the basic answer is that when we get that guy up there to sign off on it, you can't ask us anything else. All right, so they're strangling you shut. So just be aware of that. Challenging administrative decisions, review of the decision on the merits. A review on the merits generally means that a person such as a higher official, a minister, a specialist tribunal, within or outside the departmental framework, will look again at a decision that has been made and make what they think is the correct and preferable decision instead. The person conducting the review will usually be able to consider any additional material you wish to provide to them and come to their own decision about the facts of the case. They will then be able to substitute their own decision for the decision originally made. My suggestion at this point is make sure you give them every bit of evidence you can possibly give them at the time. If they don't read it and they don't review it or it's ignored, you can prove and show it was already there. But when you start producing new evidence or evidence that's old that you forgot to put in last time, or unless you can show a timeline for this new evidence being relevant, generally speaking, they say, but you didn't put it in that time, that's your fault. And you'll go, but I didn't know. They go, yeah, but that was honest on you to know. All right? So ignorance or not being educated in that area. So ultimately, my belief and my experience has shown me that you need to be a lawyer, right, as well as yourself in that situation. And the time that I've spent educating myself in psychology with all this garbage is fine. I would have been better off putting myself through a law degree because ultimately that's how much we have had to learn. Yep. If you are unhappy with an administrative decision or action, you should carefully read the act or regulation under which the decision was made to see if it gives you an express right for another or a new review. Some laws give wide rights to merit reviews, while others give none. And be careful. I don't know if it comes up in a second, but sometimes they'll say to you, you can do this one or you can do that one. You've got two options of what you can do. But if you choose this one, it must be done within so many days. If you choose this one, it needs to be done within so many days, right? But it's not a tiered thing. And you've got to sit there and work out which one you want to do because the two time frames won't allow you to do both, when in effect you should have been able to do both. So the idea is to cut it out of the system as early as possible. Do you want to give them an example of that?
I was just going to make a comment on that before. You said from my experience in dealing with all of these examples, what we went through, they seem to spend more time getting to know the loopholes of how to drop an investigation or blame it on you for not knowing than trying to prove your innocence. That's what you're up against the whole time. Like Natasha was saying, you almost need to be a lawyer to catch them out because they've got the experience in those areas, loopholes of where to get out of it. I can't think of an example right now.
I'll jump up in a minute. But yes, we were spending most of our time fending off them producing loopholes. Okay? And them knowing that I was going to doggedly keep at it. And their version of it is that I was litigious. And when they call you litigious, it means you've got a personality disorder and basically implying that I was borderline personality disordered. I was crazy. And that was what they were using as their background. But actually, my reasoning behind it was very simple. If I didn't put a stop to it, it was going to move down to the next generation. This was going to spill out into my children's lives. And I had already been told that that was the intention. Okay? I've been told that the intention was to spill it down towards into my three boys' lives. And when one wanted to become a medico, the other one wants to be an engineer, the other one's planning to go into the arts. And all three had originally chosen to go into the arts. All three were capable of going into the sciences, and they wanted to go into research. So there was a lot of things at play here. So I just dropped what I was doing in terms of a life and just started following this down to basically get the barrel constantly aimed at me so that they could get in and around and underneath me and out. Okay? So, yeah, it was a very, very structured, very insidious defamation campaign. And like, what did my youngest one say? I mean, he's just won a small films festival last year, even though it was at the Juilliard School up there doing something completely different. He just did a small film and put it in. He won the festival even though he wasn't doing film school. Yeah, he won that in LA, but he was in New York. And one of the things he said, he goes, you know what, Mum, when they talk about life stories that you could put together of how crazy it can get, he goes, the script around this or portions of a script around this would really capture people's interest, because really when a set is on and it's not even about the right thing, when you look at what occurred, you're looking at two narcissists that have made the decision they want that money. Do you know what I mean? And it doesn't bother them. There's no empathy or understanding as to what the end result will be. But the fallout for people who had nothing to do with it, people who weren't even involved. I mean, I'm just one. How many other people are in a fallout here? And how many people's lives were lost as a result? And it's a very devastating thing that you could be standing somewhere and all this can happen. And this will happen and does happen in each of these different career positions. In the case of Wanda, just happened to be there. Wanda wasn't looking to be where she was. That wasn't her intention. Do you know what I mean? Same goes with a couple of other people that have come through, and there'll be a case study tomorrow. He wasn't trying to do anything. He was doing the right thing. He was a community leader. He was a community leader, for goodness sake. He'd been doing things in the community and doing a lot of good. How can it be that certain departments, and his problem was that he just knew too much about the ins and outs of, all right? It just happened to be in the wrong place at the wrong time. And it is unrelenting once it starts. And you become fodder. Like, that's why I'm saying, why are these two people doing this? Don't they understand that they're, you're just being made a circus of? But there's got to be benefits to this, Like I said to my kids one day, we're going to go to Bougainville one day. We have to go there because something happened there and it's affected the rest of our lives. Do you know what I mean? I didn't even know about it. I had no real knowledge of that at all. Like, you've got to go there sometime because there's people there. Like, to me, there's a huge spiritual loss that's happened there. And it's a very difficult thing. And when I see people that have been vilified, I do feel that. There's such a spiritual attack that happens there. How do you rectify yourself and come out of that? You've really got to come out as a phoenix, and you need to make that decision. Okay, if you're happy with an administrative decision action, you should carefully review the decision on the merits. The following are the different tribunal courts that operate in the different states that may review a decision on the merits. ACT Civil and Administrative Tribunal, Administrative Decisions Tribunal of New South Wales, Administrative and Disciplinary Division of the District Court of South Australia, Local Court of the Northern Territory, Magistrates Court, Administrative Appeals Division of Tasmania, Queensland Civil and Administrative Tribunal, State Administrative Tribunal of Western Australia, and Victorian Civil and Administrative Tribunal of Victoria. Do I need to explain more on that? No. Review of the decision on the merits. Example, review of the decision made by APRA or Health Ombudsman decisions on a notification complaint. In Queensland, if you have been investigated by the Queensland Health Ombudsman or APRA, you can apply to the Queensland Civil and Administrative Tribunal to review the decision. And I think this is relevant to yourself and some of the events that you're talking about. QCAT can invite the decision maker to reconsider the decision. The original decision maker then has the option to vary, substitute, or confirm the original decision. If the original decision maker confirms the original decision after reconsidering it, or QCAT does not refer the matter back to the original decision maker, QCAT can make its own decision about the review. All right, so they can make their own decision on the side. QCAT can vary, substitute, or confirm the original decision. It can also set aside the decision and return the matter again to the decision maker with instructions to follow. Now do it properly. After the review of the decision, QCAT can make recommendations to the decision maker about their policies, practices, and procedures to improve future decisions. The QCAT president also advises the Attorney General about how these recommendations could be incorporated into the QCAT Act and the enabling acts to enhance the effective decision making. So basically, at the end of the day, they're supposed to improve the process. Yep, when you go to these new levels, they're supposed to hear it out fairly and work with it. And guys, take the time to find out if you're dealing with any kind of political preferences, okay? Make sure you don't go in there unaware that you may be lobbying against something that doesn't suit where they're sitting today or currently. Look at what's current. Find out what the trends are so that when you're in there, you can comment. Like I make a point of finding out what's going on. And as they're going through the process of talking to me or deciding something, I'll go, yeah, but I don't want this to be like such and such. I am aware that currently you're looking at this as your area of focus. This may not be that area of focus, but I'm expecting you to be at least neutral or available to some sort of decision. Go in there, conversational, calm, listen to everything they ask, answer their questions. But when you answer a question, always roll into it the extra things you know about what could be happening in that room. Because all of this is recorded, okay? All of it is logged. And it also then means that if something goes wrong at this point, you did highlight they could do this. They're less likely to. Okay? Never feel uncomfortable or embarrassed about protecting yourself. Okay? One of the things that happens in vilification is that everybody takes on an attitude that you should just accept it. You have no right of reply. And when you comment, you're just fighting against the just desserts that you deserve anyway.
Yep.
Okay? And make a point of feeling very comfortable with, you know, the things that I've experienced so far have not given me any indication that I'm in a neutral environment. I don't feel safe here right now. I'm doing this, but I want you to take note of the fact that I don't feel comfortable.
I've actually walked out when I knew there was 3 in the room, in the boardroom, and they asked me to come in for a meeting just about getting funding for a client for art therapy. And I knew straight away they brought something up and I thought, no, I'm out of here because I knew that they were going to barrel me for something.
Yeah. And when you're dealing with an internal, this is at the internal level, at that intra level, before it starts going out into places like the commissions that we've been talking about.
Yeah.
But you need to be aware that at every step, because you're a whistleblower, everyone is going to treat you as the enemy that is above you.
Mm-hmm.
Okay? Because their fear is that you're going to do it again. You probably will. Right? You probably will. Because once you do it once, what have you got to lose? You know what's coming next time. Yeah? And they see you as a dissident.
Which you are.
Which you are. But not really, because all that you're trying to do is improve a structure and make it safe for everybody in it, including yourself. But in their mind, you are a dissident. Okay? And they see you as a reoffender. You will reoffend. So even though you may be a criminal, you are a problem to their system. Okay? I've read that one. Challenging administrative decisions. Review of the decision on the merits. For example, review of decision made by APRA regarding freedom of information. FOI request. An applicant can apply to the relevant tribunal court for review in relation to refusing a request for access under the FOI Act in the following situations. After receiving notification of a decision made under internal review from APRA, which wholly or partially refuses access. If the applicant does not receive a notice of decision within 30 days of a valid application being received by APRA. If the applicant does not receive a notice of decision of internal review within 30 days of a valid application being received by APRA, or if the initial decision refusing access is made by the principal officer or of an agency rather than by the authorised person. An applicant has 60 days from receiving the notice of decision in which to apply for review with the tribunal/court. Following a merits review by the relevant tribunal, a person may apply for judicial review by the Supreme Court of the participating jurisdiction. Appeals of this kind may only be made on points of law.
I was just going to say this might be an example of where you've got the crossover of your timeframes, because you might want to respond to a complaint that's been made against you, and you've got a certain amount of time to do that. But to respond, first off, you might want to do a freedom of information request to get certain information. So you've got two things competing there with timeframes that they're going to take to get back to you. So that's just one example.
Yeah. And we were put in that position. I can't remember which one we were.
They took a really long time with our freedom of information request.
Nearly 2 years.
Yeah.
They did everything they could to try and get us from getting hold of the file. Everything they could. 2 years, and we were dogging them. We were dogging them on a weekly and a monthly basis, and then they would have a new time frame. And then what they would do is hand the file over to somebody else. Somebody else would leave the job, then they'd hand it over to someone else. And they were just passing the file on the tables because they did not want me to get hold of my file.
So how then can you reconcile that when you finally get it within the time frame that
the idea is for you to miss the time frame. And at the moment, I have the Australian Press Council doing that to us. They are investigating this last lot of negative journalism, and they know that I only have a certain period of time within which to lodge my new lawsuit for defamation. And so what they're doing is they're dragging out the investigation, hoping that they will have the investigation to continue past that deadline. Okay.
Is there something you can put in your application that refers to that?
No.
FOI taking so long. No. So it just has to be.
Yeah, so we just kept dogging them, and eventually I think somebody ended up feeling embarrassed and organised it, I think.
Yeah, but I think if it is happening, the important thing to do, like Natasha's always talked about, is to make sure that if you can see it happening, then you put it in writing saying, look, we're waiting on this information. I'm just putting you on notice that they're taking longer than what's required, and it's limiting me from responding. And so you've always got something on record.
Yeah.
So you end up in a paper shuffle. All you're doing is sending out emails. Making phone calls, what we would do is we make a phone call, touch base with the person, then send a follow-up email. At such and such a time, such a time I spoke to you, you said this. Then you go, okay, guys, over here, I've got that timeline I've got to meet. Here, I'm CCing you in or BCCing you in on this email that's just gone. Okay? And that's all that you're doing. And let me say, they know they've got you in that dance. All right? Talk about don't believe in a malignant authority and start to think about it. But after all of this, and as I said, after what I saw last September, their level of corruption is beyond my mind never went there. I never expected Australia, in my perception, to be a corrupt country. I just never ever thought that. And I think that was one of the biggest things I had to try and ratify at the other side of that was, oh my God. So yeah, but you need to just keep following it and following it up, and you need to put it in your phone so that it beeps at you. You need to put it in your diary. Don't go off your memory. Your memory will go. Your memory will go. You will get that stress. You need to rely on a diary in. You need to have somebody helping you. You actually will not be able to do this by yourself. You need someone helping you. You need somebody there. Yeah.
Sorry, I'm just a little bit missing a piece. With the, I do agree that definitely there's political situations that you are not politically correct. You do get vilified. So how do they feel that you were a threat if you're willing to say that? Because if you weren't advocating against them, you were just keeping quiet. You just had employed someone who knew about the situation. Yeah. I don't understand why they felt like you were a threat.
I don't think that it said that I was a threat. What had happened is, we go back a step. Somebody had set up a whole of the blogs. There was those 200 blogs that set up a plethora of bullshit. Yeah. Those blogs were used to substantiate a complaint. The board went ahead and did an investigation on someone who wasn't even a psychologist at the time, and the people that presented the complaint were not patients of mine nor clients of mine, and actually some of them weren't even people I knew. All right? But what they did is they did 2 years or so of investigation, and they made the decision that these blogs were true and correct, along with other phone calls that they made, which at the time I knew nothing about, which we only found out through freedom of information. When they did mention to me that they were making phone calls, I said, be very careful, because you already have 200 blogs that have been done by the same people. At that time, I was doing a lawsuit to get hold of their computers to prove this. What ended up occurring is that this information was disseminated to the universities and other places that I was when it wasn't supposed to be, and the decision was made that it was true and correct. So when all this came out over here, that it was a couple, just 3 people under complete mischief, just doing mischief, it came clear they then didn't want to be shown up to be wrong. So the only way to handle it is to vilify the victim, so that their organisation, their structure, their protocols were not shown to be a sham, and that the one thing I was targeting was removing the anonymity from it. I never got to see the original complaint. To this day, I have never seen what they actually presented to that board that got them to do what they were doing to my life. And then somewhere within that structure, because there's a board of about 12 people who knew all about this, which were all the primary people in Queensland in all the different universities. That university information was then taken, that information was then taken back to the universities, and all academic ability for me was blocked. I was completely blackballed from being able to do anything. And they got my marks and smashed my marks. I was a 7-level student. Suddenly I was only getting 4s and 5s, and they weren't allowing anything to be marked. When I sat for an exam, I never knew what happened in my exams. Things were being smashed to pieces. Eventually, one of the universities, somebody gave me a call anonymously saying, well, you know, everything's supposed to be put into the bell curve. Well, yours aren't bell curved. Okay? So I was getting raw marks rather than bell curve marks, which was never making any sense to me. So all that I'm saying is that's where I became the threat, because they stuffed up, they broke protocol, they broke procedure, they thought they'd found something. They'd found nothing. They'd actually been blindsided and conned. Okay, right down to the creation of an organisation that didn't exist, that actually was run and controlled by the people that put in the complaint. So that's where the threat comes. The threat isn't that you're going to do something to them, it's that you're going to highlight their incompetence. And remember, I was talking about organisations being narcissistic in their structure or borderline in their structure, yeah? Either one of those structures cannot cope with being wrong. Anybody with a personality disorder or a structure set up to exist just because it has to exist, it's dysfunctional. But the thing is there's a lot of people getting wages and a lot of people getting jobs and a lot of people surviving off that. We've got pensions, superannuations and careers based on it. Something like this coming out and going to court would have pulled the whole structure apart. So therefore, that's the threat. He got in the thick of it and he was communicating, and one of the people that was helping me at the time was simply sending out evidence going, you guys need to stop what you're doing. And he was just presenting evidence. And then, and I've got to say my eyes bulged out of my head when I read it, then one of the complainants actually disclosed that the father actually disclosed that she had been sexually violated for 3 days in Papua New Guinea and had been taken away, and that the family had never given her any therapy when she came back, and they had told her to just cope with it. Not only did he disclose that, he also wrote exactly how she was sexually violated.
Disclosed it to the media.
In an email.
And to the person
who was communicating with them. He actually sat down and wrote all these intimate details about the very thing that I've been saying was the issue, that this girl had not had proper parenting, and she was a severely dysfunctional girl. And the father just literally wrote all of that down and sent it to his office, basically admitting without saying that, yes, she's been violated. And one of the arguments was that the girl had said that her father had violated her. But when you extrapolate out from that, she had been. And I looked at that and this friend of mine just turned around and wrote, well, what kind of damage does that do to the personality? How on earth is this person being put in the media and allowed to stand up and make these statements? Blah, 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 blah. That was it. We never came near it again. But what I'm getting at, this is the level of improper behaviour that I have seen across the board from everybody. But where I'm getting from, what I'm getting at is your politicians, if they have a political agenda, you need to be aware of it when you go into any of these tribunals, because you do not know who's talking to who. And that is not that it's about you. Get that? It's not that it's about you. Don't be paranoid like that. You're always working with more than what's in that room. And you've got to hope that there is one person there that's got morality, integrity. And that second complaint and that tribunal, I just happen to have on that panel, just happened to be a professor, an Emeritus professor from UQ, who had sat and read through everything from page to page, because I supplied everything. And because he had read that, and there was 2 solicitors there, and they were gunning for me. I want to know what ethics have been broken. I said, I haven't broken any ethics. I'm telling you now, blah, 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 whatever the stories, I'll tell you later. But he turned around and sat back in his chair, looked at the solicitors and really calmly said, I don't believe this woman has breached any ethics ever. Really? Then he asked me a few questions and I answered them. And he said, I really can't see what the problem is. But then what he did do, he did an investigation into the university that did this to me, the complaint. Because this complaint was produced by a university I was at. And and the reason for that is because I had just gone through the process of going through their internal structure, using their administrative law to have the head of their department deposed. And I'd had him deposed. And what they then did is they got involved in a complaint on me to discredit me as a result of those events, which was designed to undo me so they could undo that decision. Okay, but instead what happened is that Professor Emeritus from UQ took all the evidence on what the university had been doing that I had put forward in that particular event, which I probably think affected them very much so after the fact. Okay, and the reason why all that happened to me in the first place is somebody had put in a complaint about the university to APRA, and they assumed it was me, and it wasn't. So can you see the round robin? You've got to keep looking. So yeah, so you've got to be careful. You don't know. That's like what they're saying to you. All that happened to you is because you were doing X, Y, Z with some 18-year-old. What? You just don't know what's wiring in the background. Okay, I've done all that. Okay, judicial review by a court. Judicial review is review by a court which determines whether the decision complained about is unlawful and of no effect. The court then exercises its discretion regarding whether or not to grant relief. The court usually has no power to review the decision on its merits or determine whether or not it was a decision the court would have made. The court only has the power to review the decision to see whether the decision maker made the decision lawfully. However, some of the grounds of review do require some consideration of the merits of the case. Example, if the decision maker took into account an irrelevant consideration or if the decision is manifestly unreasonable. Always seek legal advice on whether this process is available under the administrative laws relevant to your situation. So all that they are going to do is check to see if it was a lawful decision or not. Okay?
Can I just add in there, it's a little bit touched on what we've been saying the whole way, but at each of these steps that you go up, when they're making a decision, they're also considering what the fallout's going to be within these organisations if they do say they did something wrong. Not necessarily when it's just your case, they're considering that fallout as well as to what decision they give you. So the higher you go up, sort of the lesser chance you're really going to get what you want in some ways, because it's even a bigger fallout. That's why you have to push harder, as you go further up.
I'll let you do the next one.
So this is just an example of the judicial review by court in the Queensland courts.
You might want to just move a step closer to the mic, just be a bit louder.
So you can seek a review of any questions of law involved in making the decision and for the reform of procedures used if contrary to common law. You can do this by applying to the Queensland Supreme Court, with an originating application. So these are the actual application form numbers for Queensland. You're able to seek a review of decisions of an administrative nature proposed, required or made under an Act, or by an officer or employee of a Queensland government agency or local government authority. So an example of this might be with the APRA decision, the complaint that was made to APRA from Natasha, where she was actually having a problem with the actual investigator. So that's like the second point there. So he was actually not really conducting the investigation in a proper manner. So you might be able to bring it in that way in terms of how the procedure he was following. Although it has to, again, still come down to the law, whether he was following the law.
And keep in mind that when we're talking about that investigator, he was being bombarded by a borderline personality disorder cluster. Okay, a cluster, because what you actually had is you had who was borderline. Yeah, she was borderline. Yeah, had narcissistic personality disorder. Had narcissistic personality disorder. You really had a PD cluster there, which is the only way that you get this sort of complete and utter confusion and non-procedural behaviour. And you know, a lot of these government departments develop these clusters of PDs, yeah? But when you've got a cluster of a PD issue and then you throw in personality disordered and dysfunctional families and dysregulated families, there was 2 dysregulated families that had nothing to do with me whatsoever that came into the picture here that then just generated mass confusion. It was about as intelligent as that. But it did a lot of damage. And not only did it do a lot of damage, it meant a lot of careers were going to roll. A lot of heads were going to roll once this came out. So the only thing to do was to vilify the victim. Because if you don't get rid of the victim, especially a victim, you know, I think I'm a pretty neutral person. I don't think that I'm just necessarily, I'm not a fiery, out of control person.
You're the only sober one in that.
Yeah, and so you're watching it all. And so, yeah, and they're figuring, oh, this person's going to be able to tie this together. And there's going to be a problem. And you've got to realise that that board of 12 of the highest supposed brains in psychology in Queensland were letting it happen. Okay? So there's a lot of fallout.
They attract each other, these personalities.
Yeah,
they have some.
And I'll explain that on tomorrow, what's going on pheromone-wise with that and why.
If I can just ask here, okay, this is Queensland, administrative law, Queensland. Is this similar in other states? Because I don't
Yes.
have all states.
So most of the
we
time,
can generalise these principles to other
yes.
states. Okay.
If you go to the Queensland, the court's website for that state and type in judicial review, they'll have a page on it.
So if it was New South Wales, it would be very similar.
Yeah.
So we've chosen states that sort of sit exactly the same. So if they're, yeah, an atypical state, we haven't used it as an example.
The issue is, though, that there's such very stringent timelines that, you know, you're too caught up in trying to get yourself upright that you miss the opportunities to be able to actually take it through VCAT or anywhere because you've missed timelines.
That's exactly correct, because you might be so focused on taking it across into the civil law to do a defamation lawsuit that you don't have the time and money to spend on going via a judicial review sort of pathway.
I just didn't take it anywhere because I didn't think I could.
Yeah.
You're so stunned, you're just like, I don't even think I should respond. Should I even respond? It takes ages to decide if you should even respond.
Yeah, it's just, it takes a long time to decide if you can respond. Yeah.
I agree. I couldn't respond. I didn't even know what to do, who I was, let alone to take it further.
And I suppose that puts merit towards the fact that maybe a union may be the thing to put in play, because APS really should be fulfilling this role. When something like this occurs, we should be able to, because we're contractors or otherwise out there and we are an independent fraternity and we've been trained to be neutral, separate, factual, and because we sit on the outside and we're mandated to report, we are constantly going to be put in a position of being on the firing line, and also we are targets for false complaints. the fact is that we should have a body that we can go to that says, now tell me what to do. I've paid you X amount. This is what I've paid. We've got a pool of money here. What do we do for this person? And a caseworker should be attached to you, and you should have someone to represent you.
With that case,
But I was in 2 unions, and I had absolutely no capacity for assistance in either of those unions. I mean, the one was a union, and they were too busy lining their own pockets, and wouldn't deal with me. And the government union were actually bound with their hands behind their backs, and they were having meetings with the department to stop the bullying, but there was no law that they under our work cover law. There was nothing that they could do, and they just watched all of us, like multitude of people, just leaving DHS or being vilified by DHS, and it just went on and on and on.
Okay, so you might want to come around and just give that.
it's just a quick. I was just going to say, when I got thrown, it took something like 8 months for the APS to respond, and I'd sent something like about 5 emails with a great chronology of what had happened, and just, harangued them really for some kind of response. And 8 months later, I got some, too late letter.
Yeah.
And that's because they really didn't want to respond, because they didn't want to get offside of the government.
Absolutely.
So
with the money that they were receiving. Yeah.
Yeah, I do
So
believe
again,
that.
that's the political leaning or the leaning,
Yeah.
it's the other agendas you've got to consider.
All right.
So if your interests are adversely affected or will be adversely affected by an administrative decision, you have the right to request a statement of reasons explaining the decision. So that can be your first step. And then you can apply to the Supreme Court for a review of the decision if you're not satisfied with the statement of reasons for that decision. So it's a 2-step process that you can take. Usually a request for a statement of reasons is made first, and then if you're not satisfied, you can apply to the Supreme Court for a statutory order of review. The court's review covers not only the decision or a lack of a decision, but also the decision-making process. I personally would like to comment that it's important not to get caught up in thinking that the judge is impartial as well. And you'll see that when we talk about the civil law side of things. Again, if they make a decision here to say that the process was incorrect and the law was incorrect, they're considering what the cost of all those changes are going to be, procedural changes, or there might be a political agenda about whether or not to change it as well. So that stuff can be going on in the background.
Yeah, and look, don't think for 1 second that the person sitting in front of you is impartial. If you get that, you bow down to the universe and say thank you. But generally speaking, you have got somebody who has a political leaning and has made a judgment on you before you come in that room.
And have got their own reasons for staying close to stay safe.
Yes. And you need to feel comfortable with that when you make these decisions to go through these processes. You need to already ratify in your mind that you know you will be dealing with this. Okay?
Yep.
Because if you don't, that will debilitate you completely. And as we already spoke about yesterday, you're looking at a huge autoimmune response. And what came first, that or this? There's the whole autonomic system reacts to all of these things. So you need to already have your mind ready for what will be the fallout on the other side. No, you're not going to be feeling well. Already have a safety net in place on the other side of it. Already be aware this is going to be a battle. Okay? And a lot of people go in thinking that the world is just. Okay? And it isn't. And you need to know that. You've got to prepare yourself for the worst possible outcome. And I say that only so that if you get the best possible outcome or a better outcome, you can really celebrate it. Okay? But you really need to be very real. You're dealing with people, and people have foibles.
Yeah, I've actually had a VCAT win with the Social Security or study or one of those, and I actually had a win and got things changed for the better for people, so that the legislation was actually reinterpreted. So But there's no way I could even go through any of that now.
Next one. Complaint, you keep going.
Yeah. So the fourth and final sort of option is to complaint to a body such as a relevant ombudsman. You can often complain to a complaints body such as the relevant ombudsman. However, an ombudsman is usually a last resort. You should exhaust other merit options or judicial review options firstly if they are available. The ombudsman investigates complaints about decisions of government offices and agencies as well as systemic issues and has a discretion as to whether or not any complaint should be investigated. It's best to try and solve the problem directly with the relevant agency first before approaching an ombudsman. And the reason for this is that after the investigation, the ombudsman will make a report but cannot directly overturn the original decision or substitute the decision for that under review. They can only make recommendations to the original decision maker, so they can't actually change their decision. So that's why this is sort of the last step. So
you just have the satisfaction of knowing they've been advised.
Yeah.
And you've got that maybe in writing.
Okay.
This is the example. Did you want to talk about this?
No, you can go for it.
Okay. So this is the actual example, where we've challenged administrative decisions with what's actually been going on. So the Queensland Psychology Board investigated a false complaint about Natasha, which included anonymous complainants. The Queensland Psychology Board spent over a year investigating this complaint and would not disclose the names of the complainants. So that's just at that step there, that's sort of changed now as well in terms of, well, it's still possible in APRA, they will take anonymous complainants. And I'm not sure if Tasha's already mentioned yet, but in New South Wales, the Psychology Board, they don't accept it. The complaint was dismissed because the dates of the false incidents were prior to when Natasha was registered as a psychologist, and the information submitted had no relevance to treating the client and could not be substantiated by the complainant. So they were not clients or patients of Natasha's at all. The Queensland Psychology Board's final determination letter, where the complaint was dismissed, included additional defamatory information from the complaint that had not been available during the investigation, and Natasha had not had an opportunity to formally respond. So this is right at the point where they actually said we're dismissing it, and this is the reasons why they're dismissing it. They included a whole number of pages of additional information in there that tainted that letter. So what could have been something good for Natasha to, be able to show people, they dismissed it. They basically tainted all this additional information that she'd never seen before.
Allegations of abuse, allegations of violence towards other people, all these allegations, and I said, well, I need to have the details of what these allegations are, when, where, and who, and they said, well, we've actually passed them in the Queensland Parliament for a parliamentary review, intending to pull me up in front of Parliament.
So the way they got around being able to include it in the letter was to say it's out of our jurisdiction. So we just included it to show that it was there and it's out of our jurisdiction, but and it's actually said in the letter we'd pass it on to.
You've been absolved of this, however, there's all that, and sorry, that's not there now.
Yeah, we sent it to the Health Minister, and I believe the reason why that occurred is because the investigator got a massive rap on the knuckles for even bothering to investigate it in the first place. So what he then did is collected all the misinformation, put it all together, and then threw it at the Health Minister. So was that to damage me because I had his legs cut off from underneath him for what he was doing. He then couldn't let it go. He then had to keep it going in another direction.
So he took the allegations that they dismissed, but actually reinvented them in another form and gave them elsewhere.
Yes.
Pulled out all the ones that he could pull out to pass on as a payback sort of response.
Kick the cat.
Yeah.
There's a climate of fear. People don't want to admit that they're wrong.
What was that climate of fear?
Yeah, because then they're worried about being sued, yada yada. But if you take away the climate of fear, people can just say, "Look, I'm sorry. I did the best I could. I was wrong." But this climate of fear keeps it going.
But what happened is that investigator himself never bothered to read the legislation to see what he was supposed to be investigating. He did not know what he was supposed to be investigating. It should never even started.
And that's what the letter was identifying, because he spent all this time dragging Natasha through the complaint investigation. And the letter basically said it's been dismissed because it was not in the time when Natasha was registered and they weren't clients of hers.
But that did not actually come from the investigation. our professors and the heads of all those universities, who would have been made to look like complete fools.
So that letter you're saying,
Came from that body. It came from the actual APS Queensland Board of Psychology. Keep going, yeah.
That's a narcissistic action.
Absolutely.
so they defended the incompetence of that person and all that waste of
Yes.
resource, signed language.
And they defend the last day.
Yes. And then this is what happens. I could not get a right of reply in because nobody, to this day, nobody has actually told me what the allegations are. To this day, I still don't know.
It was just some lines saying these are some allegations, but not specifying anything, but enough to taint it and enough to put Natasha in another state of fear or having to think there's not something else coming she's going to have to deal with. So.
It cost us a fortune to find a solicitor who was trained with parliamentary law and this type of administrative law to go with again and then approach the health minister. And we've never received a reply from the health minister's office.
The solicitor actually called many times and sent formal letters and emails and never got a single response.
And this has been a number of government changes as well, hasn't it?
And right up until now, to this day, this can be brought up at any time and I can be pulled into Parliament at any time. It's never been taken off the table.
That's a threat over.
Totally.
They don't really want to use it or do anything. They might want in the archives.
But they want me to shut up and accept what has happened and to make no comment. And it's gone to that level because of where this all originated from, was at that level. Okay, so you've got to look at where the original stuff started. And so it's been pushed to that level to let me know.
Being attacked.
Yes.
And
To let,
necessarily defended.
so keep going.
So when that letter actually came out, we went back to them like you would do if you asked for a review of their decision. We went back to them and asked them to change that or allow Natasha the time for a right of reply, so that wasn't, she could have the information on her file, because that letter was basically in there on top of everything without her having any chance of information to go in against that. That was denied, and then the interesting thing was...
they denied me the right to give any further information to prove that none of this was true.
Which is legitimate under administrative law?
Well, not really.
But they said the investigation's closed. Our reason for putting that in the letter is because it was just to forward on to another department, so you don't have any more chance. Now it's been dismissed, there's no more chance you put more information in, so it was a way for them to close it without her being able to put that extra information in. What was interesting was then when I went to go and search for a solicitor to take on this Queensland Psychology Board to submit some of this information to them, it was actually hard to begin with to actually find a firm that we could get that actually hadn't acted for the Queensland Psychology Board. That were going to be impartial. They first asked who the case had conflict of interest. So then we did actually put in a formal legal request to them, which again they denied it. But in the end, we did actually get a detailed letter in through them via the email system that they agreed to put on Natasha's file. That was the best that we could get.
So I wanted something else at the top of that file, so that when that file was opened up, that was not the first thing the person saw, because I knew that they would then just set off another rabid response. So what I wanted to do is I wanted to put a right of reply on top of that, so that my reply to that was the first thing that was read. Okay.
The important result of that is that whenever Natasha or I do call up APRA now, we get treated really well. There is actually that has been shut down in that sense in APRA there on her file, and they just do ignore anything else that comes in relation to that information.
Yeah, there have been other things that have been occurring in the last few years, but they've just ignored it. They just, but I believe that is because we put our reply to those events up on the internet, so they could go and look, and I suppose from their experience of how thorough I have been in the past with evidence, they've just accepted that, well, yeah. But still, it's a circus, and it's a circus that can reignite any time. All right?
And as we've already mentioned, the legal communications to the Queensland Parliament didn't get any response as well. And there was a lot of attempts to communicate with them.
And nobody in that office, no one in that office would talk to us. And it's not just verbal, they wouldn't speak to the solicitors or the barristers either. So it wasn't just me. So, you know, usually when there's a legal person on the other end, they will get on and communicate. Wouldn't do it.
Why was Parliament involved?
Because what happens is if you are deemed a health risk to the community, or you are somebody that the community should be careful of, someone that the community should not mix with, to protect the Australian community, you can send in, once that investigation is over to the health minister, that health minister then looks at it and goes, oh my God, this is dreadful. And what the health minister can do is they can pull you into Parliament, and the parliamentary floor can ask you questions. They can say whatever they like to you and ask you whatever, because there's no defamation yet. There's no defamation law in place. There's parliamentary privilege. And then they can force a police investigation. And the idea was to try and get a police investigation.
And I think what they were counting on in doing that was that the health minister would look at their summary, because we kept asking them, well, we want to see a summary of what we want to see copies of what you've sent to the health minister. We've only seen a few dot points on a letter. We don't actually know what you've sent. If you haven't sent all the information, the background of what we've supplied, and all the health minister's got is your summary, then they're going to make, again, their own judgments again on top of that and start the whole process again without all the information in front of them. And at that point, it's too hard to stop, because they're taking it onto the police and things like that. It's another train. It's just...
And it probably would have all fallen over, but by the end of that, there would have been nothing. But keep in mind that the idea here was that the Queensland Board did not want me to complete my internship. They did not want me to become a registered psychologist. And the intention was to prevent me from ever getting my master's or my PhD or doctorate. Okay? Because with me carried this story. This story goes with me. Okay? So that they did not want this information or anything that I had worked with prior to that time to come into the arena. And this is where you're dealing with the old boys club. Then you're dealing with a different level. Okay? So you've got to be aware that that there's a lot of politicising, and no matter whenever a complaint goes in, it is not just your complaint and that person who's made the complaint.
And it all came, I mean, in your case, from these 2-3 people
Yes.
who were kind of making these false allegations.
Altogether,
and it was
this-
all based on some kind of jealousy or
Yes.
something.
A huge amount of envy, and to do with the fact that my children were doing very, very well. With narcissistic personality disorder, the biggest problem you've got is they've got to blame somebody else and find a scapegoat for what. So we're dealing with 6 people, fundamentally a cluster of 6 people, okay, who at that time were working very deeply in this. Now it's down to just 1, all right, 2 maybe. And after all of this went to court, they lost because we've got their computers and all that occurred. They sort of disappeared. Once it was a very public loss, they disappeared. But then it got picked up by another 3 people and it ran with there. And that's fine. We'll just work our way through it. But you've got to look at the fact that the avenue is open because of this ridiculous event that occurred back here in 1998. So there is always that opening for opportunities to step in. Okay, and you've got to keep in mind that once you've been investigated, even if you're cleared, people will say, oh, but you know what? It could be true that that's just happened because remember they got investigated for this. All right?
It's like a cancer, isn't it?
It
And
is.
all these secondaries just keep on
Yeah.
going.
And so vilification is something where you need to, sorry? So the vilification is something where you need to be aware that it's going to have a tentacle approach, and you need to prep your system for it, and you need to help your clients understand what's going on, because when you know what's going on, it's very easy to walk into it. Very easy to have a very, very calm, very different view. I'm just going to keep going from the story that we were doing before. A complaint that I submitted to the National Ombudsman's Health Practitioner, Ombudsman and Privacy Commissioner resulted in no action being taken by the Ombudsman. A freedom of information request to the Queensland Board resulted in heavily redacted documents in which the complainant could not be identified. So they made sure, because what they did is they convinced the board that their lives were at threat if I knew anything. Yet when I was saying to the board, excuse me, I am having people harass me throughout the night. I've had the following events occur to me and this and this and this. That was completely ignored. The level of stalking and harassment that was occurring, and the heinous acts were happening. You know, the last dog that we lost one at that point as well. And my children were having to deal with all of these events. Yet all those events were occurring to us, but they were saying that we were doing it to them. And the board went with that. They went with that. They allowed that projective identification to occur, and they picked it up and they believed it, which was something that I never quite understood, even though I said, look, I'll give you the documents from the police, we'll give you the reports to the police. No, they didn't want that evidence in. And they would say that they didn't want the evidence in. Okay, so, and you know, remember that this board doesn't exist anymore. And for me, I think that's quite a good thing. Yeah?
Yeah.
Although the determination letter was not changed, Queensland Psychology Board agreed to include a detailed formal reply from me to the new information I file for any future reference. So I replied in full to what I could gather of the new allegations. Okay, and to try and substantiate those allegations, which I never knew about. As I think I've explained before, they then went ahead to go to the North Sydney Police Station and went in and tried to have me charged with assault, giving a time and a date and witnesses to these events. And as I said, I wasn't even in the country at the time. But the person who had accused me of assault had actually assaulted me, and I had photos of me after her assault on me. So then I went back to the New South Wales Police at North Sydney and I said, okay, what I would like you to do is I would actually like you to charge her with assault. I will give you the date, the time, and the witnesses, and here's the photo of what I look like afterwards. All of a sudden, no, we're not going to proceed with that. And they wouldn't charge her with assault. Yet I had the evidence. So they said, they then came to me or went back to her and said, oh, but they've actually got evidence on you that you've assaulted her. Oh, I'll drop the charges now. Okay, so this is the sort of thing that you're playing with all the time. And what they were trying to do was to hide the fact that the woman had assaulted me and other people. Yeah. So it was a woman who had actually worked for me, and her husband were involved in some very unsavoury events which I did not know about. Now, when I say she worked for me, I need to point out that I had nothing to do with her on a daily basis. Okay, and she was involved in a business. She was a shareholder. So from that perspective, she was following the procedures of that business, but I actually had nothing to do with her. And then all of this occurred because she actually wanted an elevation in position, and I said, no, that probably won't occur for various reasons. And the people that were on that board and involved, the other directors, did not want her elevated. Now, once that no came, then all this started. Okay. I later took civil action on the two people that I knew had submitted the false complaints to the Queensland Board, as they had all, this is a separate story, this one, it's not the same two people, as they had also published defamatory information on blogs on the internet. The legal action resulted in an investigation to the computer hard drives of these two people and proved that they had been masquerading as a large number of people online to make it appear as if there were lots of people with the same opinion as them. As a result of the evidence in the computer hard drives, I received a formal signed apology and retraction from the two offenders, and all of the defamatory blog material was removed. The original Queensland Psychology Board complaint had been done in a similar manner to the online blogs, where it appeared to be quite a number of anonymous people provided false information to the board. The information submitted for the Psychology Board complaint was the same as what had been posted online by the two offenders. So basically they rang in and pretended to be a series of different people, and they believed all of those separate phone calls and went with it. Now, at that point, all we could really do was put a line underneath that, because we attempted to take it to the federal ombudsman to have something happen. And as I said to you, the federal ombudsman then said, oh, sorry, that organisation no longer exists. And it appears, in inverted commas, at this point that APRA has taken a very different approach to me. When the next lot of newspaper articles came out and media attention came out, it seemed to us that they didn't address that from the perspective of it being real, nor that it was legitimate journalism. And I think once we put up on the internet the answers to all of the information in those newspaper articles, that seemed to be enough. They seem to have taken a step back.
When you say you posted these on the internet, did you have your own blog? Was it on your company website? What was the
We're going to explain that in a while.
So we built some websites and put evidence up there, actual evidence, scanned in evidence, to, not just sentences to refute.
Oh, no, we didn't just put sentences up. No, that's not true.
No, I was wondering
Yeah.
if it was on a company website or what that.
Yeah, you'll find, we'll explain where it is. But the problem is that it's not really about these events to do with myself. It's about what you guys can do if these things occur. All right? So my story is really not that relevant in it, I don't feel, but it's examples that we've pulled out of it. And let me just say, what we're showing you is probably, what, 5%? Yeah, 5, maybe 10% of actual events. We're not really giving you the total. And you can imagine just with this going on, what state of mind you would be in. You know yourselves, if you just get investigated once or vilified once, and you can see that 1 or 2 or 3 people doing it, the impact on you, you've got to imagine a mass onslaught coming from all different areas all at once, and you're fending off. You're putting out fires everywhere, and you actually don't have a defined front line. Now, I can only assume that why that occurred for me to that level is because of the body that was running the Queensland board then became very concerned about what would occur because they had just foolishly jumped into something and not been clever enough to investigate it properly. Yeah. So the Bond University Queensland Psychology Board complaint. Now this is the second complaint. When this second complaint came in, I was floored by the behaviour. You see with the first one, I could on some level ratify the personality disorder dysfunction and dysregulation involved. Yep, I could ratify that. And I could, produce by blogging. Obviously, the 2 people that are doing it are personality disordered. Go to the next stage of the people that joined in the complaining with them. They were from a dysfunctional, dysregulated family unit. But this next one really took its toll on me when I realised that when people are in a position of power and they feel that power is going to be removed or the status quo is going to be changed because of inappropriate behaviour, what they will then do in retaliation. Yeah. So the 2 people that had submitted the false complaints to the Queensland board and had also published defamatory information on blogs on the internet were stalking me to each university or place of employment. So wherever I went, the guys that had done this blogging followed me. Somehow they would know where I was in my daily events. And last September, I had people jeering at me and calling out to me and telling me where I had been in the previous year. So they actually have, they follow every movement that I make. At this point, I was not aware that I was being stalked to that level.
Can I give an example of that? Yeah, there was a point when Tasha took some work down the Central Coast. And I remember her calling one time saying, she's catching a plane down there and then getting on a train to go up to the Central Coast, express train. And she's seeing the same person, the same guy on the plane, sitting near her, then getting on the train, sitting opposite, and going all the way up. And then only a little time later, suddenly all that information's been put into that place where she's working, and they wanted to get rid of her.
Yeah, it got to the point where I couldn't travel on my own. I couldn't go places on my own. I had to have somebody with me all the time. And on one particular day, it was obvious that I was no longer working in Queensland, and we were in the process of trying to move my family closer to my family. Yeah, because I was really concerned what was going on. So I had been set up by another family member who is a psychologist who organised me a job within a clinic, a psychology clinic, to work with her in this clinic. She was an employee of it, and she got me a job, basically. So I was in the process of doing that. Now, to do that, nobody knew that we were moving. Nobody knew where we were. Now, what occurred is I was on the train. I got on the plane, and as I was getting out of the car to get on the plane, I noticed a particular person, and I thought, oh, that's a bit weird. It seemed to be like they felt just a little bit too close, critical distance. With all that going on, I had a very established critical distance. And by the time I got off the plane, I was really concerned because when I went to get my baggage, it seemed this person was lagging behind. Then when I got on the train to go to where I was working, because I was on my way for my morning's work, and my car was parked where I left it at the train station, the same person was still following me. When I got in my car, and that's when I rang Chris and I said, they're going to know where I'm working. Someone's just followed me all the way to my work. 48 hours later, all this information that was up on the internet sites had been dumped into that job place. And I'll talk to you about what occurred at that place of employment as a result. But we were bracing ourselves for something, but we didn't realise it was going to be what then hit. I mean, my cars had all the oil removed out of them, all the water taken out of them, the coolant. My vehicles that I was driving in the following 48 hours had basically been sabotaged so that I couldn't even get to work. It immediately, what had been happening at the property recommenced where I was staying in this little apartment that wasn't even in my name. Yep, and I was down there on my own. So when people are in that frame of mind, it is very difficult to get them off it or out of it. And suddenly I noticed that my marks were being sabotaged. I went across to the Bond University to do what was supposed to be my honours. Okay. They would then inform these organisations of the blog material online that they had falsely created, as if the organisation should be warned about me. They used their status as a solicitor to lend weight to these communications with the organisations. They contacted Bond University in 2008 when I was studying a postgraduate diploma of psychology, which was supposed to be my honours, and that has a sub-story to it. There is a sub-story to that. Without providing me with a right reply, the academics and students within the psychology department believed the online information and started to vilify me through ostracism, gossip of this information throughout the university, and harassment to leave the university, to the point where I was categorically told by my supervisor to not enter the college grounds again, the university grounds again, that I was not to go to any of the lecturers' offices and I was not to communicate with anyone except by email. And then once they put me at that level of ostracism, they then would not reply to any of my emails. So that basically my honours year was stalwart. I couldn't actually complete my honours because I wasn't allowed on campus. I wasn't allowed to speak to anybody in person on campus, and I was only allowed to communicate by email. And then what they did was not answer the emails. But this is real life, and you would never grant it. You would never grant that this is possible. Okay? And all of this was on blogging. This was all done on the weight of what was up on the internet from the blogging. This was not evidence of any other sort except this bogus blogging. Okay? This whole university made that decision on that.
So they would call up and direct them to the blogging sites. They wouldn't give them evidence or anything. There's no evidence.
Okay? Now, additionally, a previous offer to extend the postgraduate diploma of psychology to a master's was retracted. So now, in the middle of all of this, I was supposed to be doing my honours, and I had high enough marks to go straight into my honours. When I arrived at the university, they said, yes, we'll transfer you to your honours. You shouldn't be doing the postgrad. So what we want you to do, though, this semester, we want you to repeat your marks, get your straight 7s, 6.5s, repeat them this semester, and we'll transfer you straight across to honours. But they're supposed to put you in honours at the beginning. When I came at the end of the semester and I said, okay, could you transfer me across to honours? He said, oh, the time frame for that's over. You missed the deadline. I said, what deadline? You just told me to get the marks. How could I have the marks before the date the marks were due? Oh, but the deadline was a month ago, which means I wouldn't have had the marks anyway. So basically, they removed my capacity to do my honours, and they knew that they were doing that. And at this point, the pressure went up. I ignored it, and even though I was off campus and not allowed on campus, I just continued doing my assignments and continued doing everything and kept my marks up quite high. So as that, I ended up with the capacity to get an interview into their master's program, which was a full fee-paying master's at Bond. It's not like you can do it with HEX. You have to pay up front. Very expensive master. So I went in and I did my interview. And in that interview, I got my master's position. I left that interview and I thought, okay, fine, I've jumped that hurdle. That was retracted. Then what I did is I then applied to Griffith University Griffith University accepted me for my master's and sent me the letter of acceptance, a full letter of acceptance, which means you're in, that's it. And even after that letter of acceptance, this university got in touch with them, have no idea what they said or what occurred, but I do know who made the call because it was indicated to me. Yeah. And they retracted my master's, saying that I wasn't the type of person that anybody wanted as a psychologist, citing me as unsuitable as a person to be a psychologist.
With no grounds,
No grounds,
testing,
no
nothing,
grounds,
so there
nothing.
was no diagnosis they
No,
can.
no, that
so
was
they
the
gave
grounds.
you the kind of label.
All right. But then that went on. I also was offered a position to do a PhD with CSIRO, and the university bond would have gotten a huge amount of funding for the research, which would have come out of that university. And because I had the biodynamic ag degree, organic degree here, I fitted into this slot for CSIRO that was trying to show the psychology of what was going on the farms and the properties, etc. And I had the interface professional training to be able to do that. I actually got that PhD. Same person at this university contacted CSIRO and they removed my scholarship and my PhD after accepting me. Okay. Same thing happened when I went down to Macquarie University. Macquarie University accepted me into their PhD program and then retracted the offer. Okay. So this became too much of a pattern for it not to be coming from the one source. All right. So, without providing me with the right to apply the academics and students, ostracising, etc. occurred, I submitted a legal letter to the university requesting a retraction of the defamatory actions and statements made by the academics and requesting compensation. A complaint, and we actually ended up in court with them, with the barrister, fighting for them to stop stalling my career, my academic career. They did. The next time I applied for a master's, I got the position immediately. The next time I applied for what was supposed to be a PhD, I got the position immediately. But over here, there were a series of events that occurred at that university, that so much so that I did not follow through and I jumped across to a clinical master's. I hadn't intended to do a clinical master's. My intention had been to go ahead and work in the areas that I'd been in before all of this stuff had started. Okay, so you can see that the blackballing, when they decide to blackball someone, right, wrong, or indifferent, they don't stop. Okay, now when that university stopped bastardizing my applications and my acceptances into the universities, I ended across over here at CSU. Now CSU handled the events that came afterwards completely differently. And by accident, my supervisor ended up being the guy that was the chair of the New South Wales Board of Psychology. And the way that he handled it versus the chair of the old Queensland Board of Psychology was just two completely different worlds altogether. But in both instances, I weren't aware of who they were, and it was just events that had me land in their offices. It wasn't that I aimed for there. And okay, so you can see that there's like a, you know, if you go with the concept that there's more at play than what's in front of us. Anyway, now I submitted a legal letter. A complaint was lodged. The complaint investigation resulted in an acknowledgement by the university in a letter that I had been vilified. However, no compensation was provided, and the earlier offer of a master's was never reinstated. Because I asked if I could please just do it there, because it was like 5 minutes from my home. Yeah, why do I want to travel all the way to Bathurst? Do you know what I mean? So, you know, but they wouldn't reinstate it. And at that point, they sacked the head of that department. Everybody was rolled. All the positions were redefined. But then they then went ahead and I finished my honours there. I produced a scale, a very good scale, which has now gone global by accident. Like it took a life of its own by accident. And I've in no way promoted it. But I wanted to publish that scale. And so, you know, when you have a supervisor help you in an honours program, they're supposed to be on the paper with you. I constantly communicated, requested, and he would not acknowledge my emails. So I went ahead and published it. And then because I published it in my name, they partook and supported in a complaint of me to the Queensland Psychology Board that I had no right to publish that document.
But it arose from your honours.
It arose from my honours.
Your IP.
Yes, it is. But because all of a sudden, that lecturer who had blackballed me suddenly wanted his name on it. Bullied it. He wouldn't communicate with me. And the other two people in our research group who had nothing to do with my scale whatsoever, who I had kindly gone and collected all their data for them, kindly gone and inputted all their data for them because she had kidney disease and he had cancer of the mouth. They all together put in a complaint against me saying that all of their names should have been on my scale. And I then went, what? And so then I had to go back to the Queensland Board and I had to prove that I had not done anything that had been unethical. And I said, hang on a minute, before we completed all of those research data, it was agreed that everybody's research was their own. And I said, but in actual fact, their articles that they produced should have had my name on it because I collected the data for them and I inputted it for them. They said, no, they said that they collected yours and they inputted yours for you. And I said, no. In fact, go to the library, there's video footage of it. They were never in the library doing it. And if you go through whatever it was, 1,000 pieces of paper, you will find that only my handwriting is on it. And I produced both their sets of handwriting and I said, please have a look. Oh, yeah, I signed every one of them. Yeah, each one that was collected was signed and dated when it was signed, collected. And so I'm sitting in this room with the university sending in 3 character references on me from 3 people that were never my lecturers, never marked an assignment of mine, and had never been a supervisor of mine, 3 people I'd never ever met, sending a character reference on me from that university saying that I was a person of disrepute and that article should be pulled apart and removed and that these people should be on it. And I'm standing there, I'm going, oh my God.
That someone is a person of disrepute without any
I know.
evidence or anything. This is a criminal matter.
I know. But so, of course that is. It's defamation. So here I am standing here at this second complaint with everything from the first complaint, then my reports that I'd put into the university and lodged on their behaviour. Like, I'm starting to lug around so much garbage with me everywhere I'm going because every time an event occurred and anyone looked at the blogging, everyone decided it was time for a new investigation of me. Okay? And so you were guilty till proven innocent. And the point is that when somebody with any standing goes and signs a character reference like that, and I've got these 2 legals in here like salivating that they can't imagine that academics at that level would lie to that degree. And the reason for that was because they wanted to undo what had just happened to their department as a result of their behaviour in regards to my honours, my masters, and how they had told me to get off that campus, and their derailing of my marks, and how many other masters and PhDs that I've been accepted into. I think how many have I been accepted into? It wasn't until it got to the 6th ones that we finally took legal action. And we had contacted them by email and by phone requesting that they desist. Please stop it.
Have you ever received any compensation?
No. And that was what last year was about, $6 million in compensation, which never happened. Okay? So yes, no. And what I'm getting at is that you need to understand how these systems work and you need to work them. But for every success that we got, the organisation that was pulled into line and wrapped on the knuckles then came out and did something to like what I just described. There was an inability to accept that, hey, you shouldn't behave like this. Yes.
There is a term used to describe words like disrepute, weasel word. It is an ambiguous word that can be invoked to a sense that the person has done something that's wrong, dangerous or unethical, when actually the person is describing something that a person in a position of power does not like.
Exactly. Yeah, bit disrepute. Basically what she's saying is you use that word because it's innocuous. It doesn't really mean anything, but it can mean everything. Yeah. And what it means is, well, what do you mean disrepute? What does that mean? Does she committed embezzlement? What has she done? Has she stolen? What are we talking about here? So yes, she's correct. That's exactly what a position of power, a person in a position of power uses terminology to wipe out the underlings. Now, I was very lucky because in that room, as I said, the other Professor Emeritus from the other university had taken the time to read everything. Now, when I walked into that room, he said very little, but what he did say was, leave her alone, enough is enough. Okay? But these legal eagles were up in arms because you've got to understand, for them, one of their own was already under the hammer for a range of things, and he was the one that had started the ball rolling. So it's very interesting to watch. These legal people knew nothing, but they knew that had been into whatever he was into at the time. So, yes, as a result of this, I then had to try and get into somewhere. So now I am now in a situation where I've been accepted into a doctoral program in the UK and a PhD down in Victoria. Still, the opinion that my family's got is that I shouldn't do any more work in Australia, that we should go overseas and take an exam. Yeah. Not because I'm worried about the system here. It's just that it's very difficult for anything state of the art to actually climb in this country. Okay, so other administrative law options. Appeal to an internal review board of a company or large organisation about actions taken by their employees prior to taking the step of legal action. Example.
You just described
I've described it?
About it on university.
Yes, okay. Submission of formal complaints to other statutory bodies. Now, what we ended up doing is because they were claiming that I was a cult leader and they were using that was the reason why I should not be allowed to go on and do psychology. Okay? My own. My own. And I only have one member, and that's the member that's gone to the media. Do you know what I mean? That's it. That's my cult. It's the one person that's gone to the media. That's it. Sum total. Okay? I'm an incredible cult leader. And I didn't even know she was a member.
And what is
That's the bit that really gets to me. I didn't know she was a member. Submission of formal complaints to other statutory bodies. Anti-discrimination. Now, because they were claiming I was a cult leader and they were using that as the reason why they would not let me into any of the universities, we went to the Anti-Discrimination Commission and said, look, I'm being discriminated against because of my religion. I have this religion, which I don't advocate to. I'm Russian Orthodox, but they're saying I have a religion and they're saying I'm leading a religion. And because I'm the leader of this religion, which I have no members of my church, I just need to remind you guys of this, I want you guys to step up and do something for me because that's what you're supposed to do. You're supposed to deal with minority groups and people who are religiously or racially vilified. Now, there is just one of me in this cult and only one person in this church. I want something done about it. Well, we got a reply back that said, well, we had to do that. We had to cover every angle. We had to go down every administrative law track so that we covered every base. Okay, so that eventually when it went public, if it did, we could state we had done X, Y, Z. All right, otherwise people look at you and go, well, why don't you do this and why don't you do that? So we were saying, oh, we're going to remove all the whys. We're going to get them all out of the way. What did they say? What did they say after all that? You put all of that towards them. They investigated it, by the way.
Because it wasn't considered as discrimination.
They said what?
It wasn't considered as discrimination.
They were basically saying it's a religion that didn't exist, so yeah, they couldn't investigate it.
There you were absolved then.
Yeah, I know. All right.
So what if you, this is just an example, what if you were some sort of leader?
So what?
So what?
Exactly. It is that. So what? So what if I was? I'm not, but if I was, so what?
Yeah, well,
and that goes to show you how strong that word is. What does it mean? Cult is actually 4 letters out of the word culture. All right? It means that you are living a different culture. That's what it means. It means within a culture, you are living a small version of a culture within that culture. That's all that it means. It really, that's what the word is. And one of the solicitors that I had kept repeating to me, well, we've got to get this in the court because we've got to ask them what is the definition of a cult? What do they actually mean? So far, we have no definition as to what it means. We have popular version of what people may think it means. We also have what the media says it may mean. But what is it in fact? So basically, and it's irrelevant. It is irrelevant because it doesn't exist. But my point is that when you are labelled with something, now you're a person of disrepute. Okay? And on we go. And this is why I get very concerned if people are being vilified, because it's on a much smaller scale and you're in a much smaller world. And not that I'm saying that my world is bigger. My world got very big very quickly without my knowledge or my awareness, if you can understand what I'm saying. But this same thing can happen within. And what goes on amongst our colleagues is very concerning, as we then saw at this clinic down on the Central Coast, what then occurred down there.
But
It was horrific.
it also gives you the example that Natasha has said before, I'm not sure, that they expect you to, when they are vilifying you, they expect you to sit still and lie there and take it. And if you don't, if you buck up and you start to fight it, then they just keep on vilifying you.
Which is one question I do want to ask at some point before we conclude this whole thing, is what happens if you just say, thank you very much, I don't have to fortitude what you've got, I'm just going to step aside, what are the consequences? So I want to park that question.
Yeah.
Maybe you'll get there.
We'll get there. We will get there.
Yeah.
Because you know what, at the end of all of this, I'm going to say to you, don't do this.
Well, that's it. That's where I'm going with this. It's like,
Do you know what I'm saying?
yeah, totally.
Get some really good consultation, and it will back me up when I say, I just said, don't do it. Island hop move.
Yeah.
You've got an opportunity now. Smooth it all out. Smooth the waters out. Move somewhere else. I mean, I had no choice.
And your stakes are far too high.
Yeah.
On so many levels.
Yeah. I had no choice. But if you have a choice, do not do this. Okay? I am not advocating doing it. Not by any means. I'm giving you the education to let you know that I understand. Have a look at your situation. Calm your waters as much as you possibly can. Figure out where you can come to a point of peace with yourself. Yeah? And step aside. It's unhealthy. But understand one thing, okay? I had 3 boys and there was only me to protect them. And I think that when you take a mother and the mother knows that the cubs will go if she doesn't step outside of that cave and protect them, I think it's as basic as that at the end of it. I got taken into the system. I got taken into the system when that first current affair hit. Okay, and at that point, I was living a very good life. My life was nowhere near the system. It was never. I owned an organic, permaculture-orientated, biodynamic 100 acres. I had an organic, AAA grading for my property. My kids were brought up on organic food and alternative food. We were grinding our own grains. I was not in the mainstream. I wasn't interested in changing the system. I believe the system had its place. Different horses for different courses. Okay, some people needed mainstream, some people needed religion, some people needed whatever. Whatever they need to do, they do. Some people need a psychologist. It doesn't matter what it is. I was here. Okay, and I believe that you could take the golden thread out of anything and do well. When this happened, I suddenly went from there to here into this craziness, and then I had to make a decision.
Yeah, but what I was thinking when you were dealing with Alpha and all of this, that because they are respectable, supposed to be respectable organizations, so you believe we all grew up somehow believing that there is a justice and goodness out there, so you go, you prove your evidence, and that's why you prove this.
I went, no, that's not what happened at all. What happened is I then made the decision to upgrade my degrees, because at 20 years, if you're not aware, 20 years your degree's outdate, and unless you do something, another postgrad, you lose the value of that degree. You need to check on your degree dates. A lot of people are not aware of that. So you need to upgrade every 20 years your last tertiary education to keep yourself current. Now, I thought, okay, I'm coming up to that point. I've just gotten through looking after a terminally ill husband who's now an ex-husband, a child, all sorts of other issues were there. So, okay, I'll just do a bridging degree. Okay, maybe that will just stop all of this. If I do a bridging degree, and I went into psychology. And then it started. It was just like madness. Now, when I got initially reported, I never even knew that systems such as that existed. When I got that first letter from the Queensland Board of Psychology, I didn't even really realise that system existed. Got that? I don't believe I trusted that system. I just made sure that when I dealt with that system, I dealt with it thoroughly. Because at that point, I had, after nearly 10 years of being subjected to straight up harassment, I knew I had to do it properly. So no, I didn't believe in any of these systems. I'm saying if you're going to work in them, work through them thoroughly. Learn your legislation, work out what your rights are, and quote out of it. Okay, because they're not going to look after you. Okay, and I'm saying that's what I'm saying. No, I don't believe I trust it. I didn't go in there expecting, and I have never really expected it to be a justice-orientated system. Although I did expect our legal system to be. Yes. That one I did. This I just figured was paper shufflers. These are paper shufflers. These are people who live by the word of the written word. They're not thinking. There's no emotion. There's no empathy. It's not designed to be an empathic process. Okay, it's a pathological process. Okay, so that's the world the administrative law lives in. You are guilty till you prove yourself innocent, and don't go in it thinking that anybody cares how the outcome is. They're just going to follow the letter of the administrative law. However, civil law you can change law by setting a new precedent. That's where you can make a difference. And that's where I went in the end. Okay? And I'm still trying to catch these guys so that I can get these guys into a civil law situation so that the civil law will force them to do some changes. Okay? Which occasionally happens. And what happened is the Queensland board knew I was marching in that direction. They closed their doors and disappeared. Okay? But then they didn't stop. The individual members, not all, but some didn't stop. Okay, other administrative law options. Notification to regulatory bodies under the person vilifying. Example, the two offenders that filed the false complaints to Queensland Psychology Board and posted defamatory online blogs were a couple that worked as a registered nurse and solicitor. I submitted notification complaints about each of these two people to APRA and the Legal Services Commission with the evidence of their deceit online and misconduct as a solicitor, including forging his signature. They actually forged the signature on their apology to me, which means that their actual apology to me is not valid. It's an invalid document. They did not give me their correct signatures. All right, this is a solicitor who is doing this. The online blogging and the complaints were dismissed without investigation, proving that sometimes litigation under civil law is the only viable option to achieve vindication. Now, that nurse that spent all those hours doing all that blogging, has a mental health issue, and they did not investigate her, yet they investigated me on false allegations, and I actually submitted proof in both cases for both these people to their differing ethical bodies, and neither of them were investigated. Okay? So you need to understand that sometimes there is simply politics at play.
Yep.
Can someone be tried under both civil and criminal law? Yes. Somebody can sue you civilly while the law courts are taking you through their system, their judicial system. Both a civil and criminal action can be brought against someone. Often a civil case can succeed where a criminal action has failed because the standard of evidence required in criminal matters is higher. So what will end up happening here, sometimes what will happen, and read this again, a civil case can succeed where a criminal action has failed because the standard of evidence required in criminal matters is higher. Yep. So if something happens that you can't get that person through the criminal system and you have the funds, you can go through the civil system. All right, who's a good example of that? The fellow in America.
Oh, the murderer.
Yeah, the one that killed his wife. So, he got away with it through the judicial system, but in the civil system they found him guilty. Okay. Local court versus Supreme Court. The court where a case is heard will be based on the value of the damages claim being made in the civil action. For example, in New South Wales, if the claim is under $10,000, it will most likely be heard in the small claims division of the local court. Commonly, a large claim of over $750,000 will take place in the Supreme Court. Defamation. Definition. The publication of any false imputation concerning a person or a member of his family, whether living or dead, by which A, the reputation of that person is likely to be injured, or B, he is likely to be injured in his professional trade, or C, other persons are likely to be induced to shun, avoid, ridicule, or despise him. Publication of defamatory matter can be A, spoken words or audible sound, or B, words intended to be read by sight or touch, or C, signs, signals, gestures, or visible representations, and must be done to a person other than the person defamed. To succeed in a claim for damages, the plaintiff must establish that A, the matter complained of was published, that it specifically related to the plaintiff, and that it was defamatory. Publication requires that the imputation be made to at least one third party who is not the husband or wife of the defamed. So what I think you're asking is, with criminal law, it's about punitive actions or reactions to actions that are done by the person who's being charged. And then a civil case is more about looking for compensation and damages. Yes, in most cases.
Oh, sorry. I thought I might speak up. I don't think that my typing is fabulous today.
Yeah, go for it.
So I was just going to say that my understanding of the system is that for criminal matters, because it is normally, as you said, punishment or punitive based, that they work on an innocent until proven guilty system.
That's
Whereas in civil cases, because it's normally more to do with compensation, there's less of that criteria because they're kind of asking, is it on balance? So rather than being an assumption of innocence, is it likely that this thing happened? They're just kind of asking, is it more likely than not?
Yes, that's right. And so what they're looking at, if it has happened and it's more likely that it has happened, what we're going to do now is we're going to compensate you X amount. All right, so the publication of defamatory matter can be by a spoken word. I've done all that. To succeed, the publication requires that the imputation be made to at least one of the third party who've done it. All right. A very large proportion of vilification cases involve defamation in some form, so it is important to become familiar with the defamation law that applies to your location. In Australia, the Uniform Defamation Act was passed in 2005 with a commencement date of the 1st of January 2006, so that there is uniform defamation law in all states and territories. Now, basically, if you sue for defamation, everything else in court comes in order. Straight away, the defamation goes to the top of the list. Supreme Court will put defamation cases above all and will put them at the top. So once you start, it moves fast. Australian Uniform Defamation Act. Multiple defamatory imputations in the same matter media comes under a single legal cause of action. Multiple incidences of defamation in one newspaper article are tried as a single statement of claim in court. Now, basically what it is I did something that nobody else has done before, and I think it's what really upset the judicial system and everyone, is that when I did the suing for defamation of the media outlets, I sued the 2 media outlets and the 2 journalists personally, plus the people that they used as their witnesses. All right? So normally what happens is you just sue the newspapers, and what that means is they get to keep the journalists and the witnesses for themselves to use in their court case. But I didn't do that. I sued them all individually. All right, which meant that they all had to pay money to get legal representation. Okay, so I forced them all to start spending money, which is what really upset the judicial system, because it meant that they then had to deal with 6 of these people over here, 6 defendants, not 2, and I was making everybody cough up because I figured, bugger this, I'm going to lose everything. So while I'm losing everything, you guys can start coughing up now.
So were the journalists not protected under the employer?
Oh, they were, but it meant that the employer had to play double. Okay, it meant that they had to look after this constantly, both sides of it all the time, which also meant that the employer became more and more aggressive towards their journalists for what they had done in terms of putting forward such unethical articles. Now, I know that both journalists that did that are now in outer land. Out there somewhere, right? Because my life was going to end as a result of their actions, and so I figured you guys can really, for the first time ever, be accountable. And one of those journalists, he's now gone ahead again. He can't control himself. He's so impulsive and so narcissistic. He was a part of a cult. He grew up in a cult. He had something happen to him in a cult, and his mind is not right. His mind is not right. He doesn't understand anybody that's got that name attached to them. He runs around like a maniac. He's completely biased. Okay, and what he's doing is, completely projective identification is all that's going on here. Yeah, and it's constantly transferring. Now, fine. But then that cost those newspapers a lot because he was like that. He no longer works them. Okay. So multiple defamatory imputations in the same matter, blah, blah, blah. Under the court orders otherwise, either party may elect that the proceeding be tried by jury. Now, this is where a lot of things started going wrong for us in our last court case, because we had a solicitor who was supposedly an expert in defamation, but wasn't. And we didn't find out till very, very towards the end. Okay? And his understanding of the defamation laws in the different states, even though it's a federal, under a federal act, there are separate imputations in each of the different states. There's different ways of doing it. And he didn't know that. Okay? General damages for non-economic loss are limited to 50,000. This accounts for a person's loss of reputation, shame, or hurt. That's all you get, $250,000 for never being able to work again. Okay? Special damages compensate for any loss of business or earnings the plaintiff may have suffered as a result of the defamation, and our special damages were high. Aggravated damages can be awarded if the court thinks that the defamation was deliberate, possibly out of ill will or any other improper motive, and we could prove malice. Okay? Defamation law commonly requires that in order to prove damages, you must provide witnesses that read the publication and thought negatively about you as a result. The difficulty is that these people are now unlikely to want to be a witness for your case. We had our witnesses. As we got closer and as we lost our solicitor, all of a sudden, all of our witnesses, each one was touched individually and backed out.
Can't they be subpoenaed?
They can be, and we would have.
Would that be a friend though who says, I cannot see how this could be related to my claim?
Oh, yes. Somebody can come in as a character.
I'm appalled.
Yeah. A character witness, and only character witnesses that know you on a daily basis will carry any weight in the courtroom. And of course, it would be a friend of good reputation. Yes.
I was just going to say, but to prove your damages, it has to be someone who read it and thought negatively of you because of it. And that's the problem, is that anyone who has thought negatively of you because they read it is not going to want to come forward and be a part of your case, or they're going to be afraid that if they do, that you might sue them or something like that. So it's really hard to get the witnesses you need to prove the damages in a defamation case.
All right, and we had those witnesses until the two people that I spoke about from Q Health went and threatened all the staff that they would lose their jobs if they went in. The staff were willing to step up. That, I must admit, the integrity and the morality within that actual team, after all of the bullying and everything that went on, which in some ways was incredibly comical and ridiculous, at the end of all of that, every one of those members involved in that was willing to step up and go to court. And then their bosses stepped in and said, no, you couldn't, which then propelled a number of them to change jobs or leave, who then were willing to do it outside of their job descriptions. Okay? And it didn't affect their new positions at all. It is important to be aware that defamation law commonly has a limitation period that applies, whereby you must start any legal action within a certain period of time since the publication occurred. Example, in Australia, this is commonly 12 months, with a possible extension to 3 years under certain circumstances. If the defamatory material was published online, the limitation period does not apply while ever it remains online. However, the moment the material is removed, the limitation period starts from the last date that someone downloaded and printed the information. Keep that in mind, okay, with online defamation, all right? And in America, even though it stays online in America, once that 12 months is up, they no longer consider it defamation if it's still up there 12 months later. But in Australia, it will be considered it. So our laws are the best laws for defamation currently in the Western world. So as much as Australia has a number of issues going for it in some areas, our defamation laws are the best. So we are very well protected here, and you can use them civilly in the civil law system very, very well. Therefore, if the publication is online, download and print it off on a regular basis so that you have the maximum limitation period available in which to take legal action if the information is removed from the internet. Okay? Now, just before we jump across to that, retaining counsel, I just want to mention one thing. Remember, I had a court case last year. We made an agreement, they removed it, then a new lot of defamation was put up online. I just want to mention with that journalist, he believed so strongly in the false story that had been told to him that he went and set up a Twitter account to specifically have people tweet about me. And the only tweet on that Twitter account is him. And there's one. Okay? So even at that last point, even after all of this, after all the evidence was put forward, he still couldn't accept there is no cult. Okay? So if that delusion is locked in and that narcissism is locked in, they cannot and don't know how to stop. That same journalist stalks his contract work. Because they knew this was helping me, they started stalking his contractors and his contract work to kill his income.
It was actually a grant program that I'd been awarded. He tried to get in to ruin that grant program, to ruin funding.
Yeah. And it just happened that the caseworker that was working on that grant program was following protocol and wouldn't disclose any details. But the idea was to get the details on it and then to go public with it. So this is what I was saying. The stalking. Now that's completely inappropriate for a journalist to do that. Well, the thing is that's beyond journalistic jurisdiction. That's just destruction.
But that whole UK phone hacking thing is
Yes.
Yeah.
I'm telling you, in my view, their rights need to be limited. I think that they're too broad.
Even if they are, they go.
I understand.
Exactly.
I understand. But there is something wrong there. There is not enough policing, and there is a problem there. Same as what they ended up doing to Princess Diana. That death was unnecessary. How dare they? How dare they think that it's okay to do that to another human being? It's the same thing. It's mobbing. But it's mobbing by a particular cohort in a particular career. Okay? Retaining counsel. Before taking any steps to start litigation, make sure that you have obtained the service of a solicitor that you can trust implicitly. For any solicitor you are wishing to engage, it is recommended to consider the following. Where possible, conduct detailed research on their employment history and their areas of expertise. Speak to anyone you know that has had the solicitor act for them. Or look up what court records are available to you in order to determine their success rate with cases and the types of cases that they may have been successful with. Choose a solicitor that is experienced in the local or state laws applicable to your case. Do not use an interstate solicitor, as fees will be much higher. They will have to engage a town solicitor at extra cost for filing and court appearances on their behalf, and they will have less experience with interstate laws. Like sometimes we would fly and get him to lodge the documents, fly to go and do it rather than pay somebody else to do it. So you need to consider, if you're going to go about these things, how will you do it? Okay, look at your finances and your legals. Ensure that the work history of the solicitor does not show previous employment by the industry, the types of organisations of the government departments that are related to the vilification that is occurring for you. Now, we found out too late that our legal representative had actually worked for other newspapers and these newspapers. We found out too late in the piece. So what we had is we had a constant backdooring that we weren't aware of, and we did not have a solicitor that was sitting on our side who wanted to go in and change precedents. Okay, and not only that, we eventually found a firm that was going to do the work for us pro bono, but he had undermined it to such a degree that even the pro bono solicitors at the end could not jump in and help. Would that be a good summary?
We actually had a barrister who was going to do it pro bono, and all the barrister wanted was for the solicitor to give him a summary of the case so he could get going on it. He sent him direct emails. He put in an affidavit to the courts about how the solicitor avoided it until it got to the point where there was not enough time left for him to get up to speed on the case before the first hearing. And then only at that point did the solicitor start to say, oh, I'll start communicating with him.
But the reason for that is that our solicitor had already made the decision that we were going to accept an out-of-court settlement. And he and the 6 parties we were involved with were together pushing us for an out-of-court settlement. So he deliberately didn't send those documents and delayed so that we would I would bow down and say, okay, I'll take an out-of-court settlement. Okay? But we weren't aware that was a chessboard game we were in. Actually, we were very innocent at that point. I specifically had not caught on to that. It wasn't until I was in court and I saw what happened that day, and my barrister who arrived, who was a different barrister to this one, let me know that that was what had happened.
And that barrister that was willing to do pro bono, he was an expert in defamation and in complaint cases for health professionals. And he actually submitted an affidavit to the court, to the judge, saying how inappropriate the solicitor was and detailing the communications. He tried to get in touch with him and he wouldn't bring him up to speed. And the judge still ignored it.
Yeah, and blamed me completely for it. Laid it at my feet.
A barrister submitting an affidavit and it was ignored.
Yeah. So, and that's when you know that you're courting something. It's not. There's a political agenda at play. And fine, that's how it goes. Once counsel is retained, you need to be realistic that you are emotionally involved in the litigation and its potential outcomes and risks, whereas your solicitor is not. Keeping this in mind, the following points are important to understand for a successful litigation. Self-educate. Learn about the applicable laws and your rights within those laws. Do not assume that solicitors know everything about the laws applicable to your case. Your solicitor has to fit in your work amongst many other deadlines, whereas you can plan ahead for time and research in more detail your options. Make use of this so you can be informed of what may occur in the case and what strategies you can take. And make sure that when you're planning ahead, that you put in your diary when the deadline is and start harassing 7 days or a week before to make sure they do it. Because if you don't do it, what your solicitor will say to you is, oh, I couldn't make it. You didn't give me the information. And they will always backhand it into your lap. Any deadlines missed will be your fault. Even your solicitor will send you emails explaining to you how it's your fault. All right? Be aware they do the same thing. Have confidence to ask questions. If you think your solicitor has missed something or you don't understand a process, if you are paying your solicitor such high rates, you may as well get a free legal lesson at the same time. Okay? The more you learn, the more of the work you can do yourself to save time and money while using the solicitor only for final drafts and representations. We did all of our own drafts and affidavits because they can't spell. They don't write good English. Their English is horrific and their spelling is shocking. And you need to do it yourself. I've not met one yet where we haven't had to correct.
That's close as we've gotten.
Yeah. All right. So, and when they put in a document that is not well written and does not have correct English in it, the judge or the magistrate will react to that. Okay, so correct it for your own sake. And they will comment on it. They will call them tardy. So communicate everything with your solicitor in writing by email or letter, always without fail, and follow each email up with a phone call to make sure they received it. And every time they talk to you on the phone, our last conversation you said, and we agreed to this. Sit there and swipe technology, your phone, and send it straight in because they'll deny the phone call happened. Stay focused on the goals that you want to achieve and continually see if this matches with what the solicitor is doing or proposing. The way solicitors are trained and the manner in which they bill by the hour, they are process orientated rather than goal orientated. Therefore, they often remain focused only on the task at hand rather than the long-term goal. Do not assume that the solicitor will have your deadlines for your case at the forefront, which I've already said, and you will pay for these mistakes or omissions. You will still have to cough up and pay the bill even if they get it wrong. Check over the itemised bills from the solicitor. Do not assume that the bill will be accurate at all times, and they won't be. They will overcharge you. Query your charges. If the solicitor provides you with an estimate for their services to take on a legal matter, it is prudent to double or triple this figure. They will do anything to get the business in the door. Once the process starts, you're stuck with them, and they will get it to cost more, and they will charge you more, and they will take their time. To arrive at a more realistic estimate for the cost of litigation. Do not place large amounts of funds into the trust account of the solicitor, as the more money that is available, the more they will charge unnecessary expenses and time against. Place money in trust in portions as each stage of the work is completed. We never gave them the full amount. Every time we did that, we'd watch them chew it up in a month, 30,000, 40,000, 50,000. They'll just chew it like that. And then you'll go, hey, where did it go? Oh, and they'll list off all these things. But if you give it to them in small chunks, they've got to work for each step of it. So you need to use their system to your advantage. Lawsuit. Defamation is a legal action for defamation was taken against two people that had submitted the false complaints for their published defamatory information in the blogs. We've already covered this really, haven't we?
Yeah.
Nothing else to
Yeah.
cover for it. Okay, I'm not going to get into that. Recording of conversations and use of surveillance devices. Well, I'll let you do that.
Okay. So there's been a few questions in previous workshops about whether it's illegal to record conversations when you're getting vilified at work or things like that. So we've just done a little bit of information on that, just looking at the acts that apply to it. So it's not illegal to record a conversation without the other party's knowledge. It's not actually illegal to do so. You can make a recording in order to assist you in preparing an affidavit to jog your memory. So that's the main purpose that you can use it for. It's very unlikely that you'll be allowed to use the recording as evidence in court if the other party was not aware of it when you were making the recording. The Evidence Act makes it very hard to get that through. Under the Surveillance Devices Act, certain instances allow for the recording of conversations. What is allowable differs in each state of Australia, which I'll show you on the next slide for each individual state. However, most states allow for recording to protect your lawful interests. If you have made a recording to protect your lawful interests and you wish to use it in court, you will still have to argue for it to be accepted under the exemptions of the Evidence Act. So you're working with both the Surveillance Devices Act, what it allows you to do, but then if you want to use it in court, you still got to work with whatever the Evidence Act will allow you to use it in a court case. An example of a case where the recording was previously accepted in court is where the person was being threatened with blackmail continuously. So they were aware that the event or conversation was going to occur. However, it's not valid to use the argument that I thought that they might say something. So because that's to stop people from just continuing the recording, they might catch something. So that's not really going to get you to allow you to use it in a court case.
And you really need to be very clear in your own mind that you are at risk somehow. And you can't just do it on spec. You need to go in there knowing you could be at risk. Like, for instance, these gentlemen that are, come into your office or your practice and they're demanding X, Y, Z, that needs to be recorded. Yeah. And the video recordings are virtually always accepted in court. So sometimes it's better to, rather than press the speaker record, that you press your video record. And even though it's moving around in your pocket and whatever else, you've got it sitting on the table and staring at the screen, at the roof. The thing is that you can't dub or change a video recording as easily as you could a voice recording. Okay?
So it's more reliable.
In the eyes of the court. Okay? In the eyes of the court, it is more reliable.
So this slide just gives you a really brief understanding of some of the aspects of the Surveillance Devices Act for each state that might apply to us outside of the police force. It's still really hard to interpret when you read them. So if you were going to do something, you'd still want to get advice from a solicitor just on the interpretation of it. I've put every state up here just so you can see which ones might apply to you. And you see that it can differ quite a bit. So in New South Wales, it is possible to record the conversation if it is reasonably necessary for the protection of the lawful interests of the principal party. In Victoria, South Australia, and Northern Territory, it is possible to record the conversation if it is in the public interest, for the protection of the lawful interests of the person making it, or it is in the course of legal proceedings or disciplinary proceedings. Western Australia is the same as Victoria, South Australia, and the Northern Territory, with the addition of using a listening device to obtain evidence or information in connection with an imminent threat of serious violence to persons or of substantial damage to property, in the performance of the duty of the person making the publication or communication which we use. So that point's sort of about possibly that if it's a regular thing that you do in your job to be able to make communications or publications that you need to record it, so then it's allowable. So I think that might apply more to the police force, but if you had a job where that was occurring, that's where you'd want to check on the fine sort of points in the law of that. That's usable for you. Tasmania is the same as for Victoria, South Australia, and Northern Territory, with the addition of using a listening device to obtain evidence or information in connection with an imminent threat of serious violence to person or of substantial damage to the property or a serious narcotics offence. Queensland
was actually quite convoluted and a lot harder to work your way through their act. But with Queensland and the ACT law did appear to be quite similar in terms of how it might apply to us. They didn't actually have anything there about being able to use the recording to protect your lawful interests. But it allows a recording by a person who believes on reasonable grounds that the use of communication is necessary to help prevent or reduce the risk of serious violence to a person or substantial damage to property. So you can see it does differ a lot between different states. But I would say, going back to the previous slide, the main reason you might want to use it is to come back to as a recording, just to jog your memory so that you can actually put down a good affidavit of what actually occurred. He said, she said, right down to the finer detail.
Surviving a license, do you want to do this or?
Well,
Go for it.
yeah, this is a good book that I came across on the internet, where they've actually pulled a lot of evidence information together on false complaints over the years. This is in the US, but it does have a step-by-step guide in there on things to look out for, on how to survive a complaint with the board. It is US based, but I think there's still be a lot of relevant information in there to surviving a complaint here in Australia.
If you can understand it from the complaint systems of the US and you cover yourself, right, following that, you will pretty well cover yourself for anything that can happen in Australia. Okay, because they're much more pathological over there. Okay, a lot more. And you're dealing very much from a patriarchal system. It's an incredibly controlling system. It may all look very polite and fine on the surface, and all the niceties are there, and everybody follows all of the etiquette of the best manners in the world. But the amount of undertone and the subliminal messages that are going on are unbelievable. The silent threats are very different to here. We're much more overt in our behaviour here. In some ways, it's easier to negotiate. Okay, so this book is very good because it will probably give you every tool you need.
How much of the situation needs to do with having social capital? Like, you know, when you're the new person or you're the outlier, as you're saying, but then you build social capital, people understand that you actually do know what you're talking about, actually are a decent person. Like, how much of the thing is about that you need to build social capital so people know that you know that you're a reasonably trustworthy person versus that there's actually like a hierarchy and that everyone's worried about protecting their status quo?
I think both runs concurrently.
Yeah.
Okay. Can you just repeat what the question
So that was, you're asking how much is it about building some social capital?
Yeah.
So that gives you a better standing.
amongst
Yeah,
the cohort?
in every group, basically.
Both happen concurrently. Okay, you need to build your social capital. If you listen to my story as I've gone along, you will hear that I've been building social capital at the same time as being the new kid on the block who also comes with this history that they're going to go and use and investigate again. You've got to have it all happening concurrently. And in Australia, that's a very brilliant rule of thumb. However, as the new kid on the block, you're treated with a lot of respect and you're put on a pedestal. You have to do a lot to fall off that. It's a very different attitude in America, in the US, and even in Asia. I'm not US, I'm in Europe, even in Asia. It's here where the new kid on the block is already off and down and they won't let you climb up. So just be careful, it's very different. All right.
So we're going to move on to the social media side of things. So this is some information to help you get an understanding of the social media side of it. If you've got information up on the internet that needs to be removed or pushed down that's negative or false, these are some of the ways that you can go about doing it. There's a lot more detail to it, but this is sort of just giving you an idea of where to go. So the following are options available to you to assist with the removal of unwanted publications within social media, such as the internet. The first one is to send a legal letter to the original media organisation or website that published the material. Even if you know the letter will be ignored, this is commonly the first step to take before filing a statement of claim against the organisation or individual under civil law. And that's actually expected within the civil law system as well, that you would do that first, to give them the opportunity to remove the material and make amends. But most of the time, you won't get a response. Where other websites, print media, TV or radio have republished the original offending materials, they've taken that material and republished it on another site or advertised it, You can send them a legal letter informing them that any republication of that original defamatory material is also deemed as defamation. As with the point above, this letter is the first step to take before considering legal action, and sometimes it does actually work on the internet. I have had some experience there where it will actually work because they're not as invested in keeping it up there as the original organisation that published it. So a number of times they have actually gone and pulled it down, but then other ones have gone and pulled it down and tried to find something else that is there that they can put back up in place of that. So. The third step is to go to Google to try and request them to remove the information. In Australia, it's quite limited, and but I'll go through what you can do here in Australia, and then on the next slide, there's also some information about what's happening over in Europe as well. It's a little bit better off for them over there. So the Google removal request can be used to attempt to remove the original defamatory material or any sites that republish the material, but only from the search results. So even if they remove it from their search results, the website's still going to be out there somewhere. Someone still could access if they type in their web address. It's just not going to show up in the Google search results when they type in your name or things associated with you. So you haven't actually removed the material off the internet. Google in the first instance will ask you to instead approach the webmaster that controls the publishing of the website that holds the offending content. So that's like the previous steps of sending those letters. If you don't make this first attempt with the webmaster and Google deletes the site or image from the search results, the web page still exists and can be found through the URLs of the site, social media sharing, or other search engines. Google will remove sensitive personal information or content that is unlawful or that poses a risk to human safety. So they won't remove information that is generally considered possible to find out about in public domain, like your birth date and your address. They won't go and remove that sort of thing. But if it's going to pose a risk or it is sensitive information, then they will look at removing it. So these are I've just put up there as the URLs that you'll click on to go to request. They've actually got a web page there with some information on what steps to go through to request it of them. One of the important things that I wanted to point out, that if you're going to do this on this last point here, is that if you are going to do this request, you want to do it in a formal legal letter, and you want to include as much information as possible so that they get everything in that first hit and they don't waste time backwards and forwards or giving them an opportunity just to dismiss it. Because you're dealing with an organisation that's somewhere else off there in the ethers, you want to get them everything up front, so they're don't have a chance or a loophole there to sort of dismiss the request. So that includes your country of residency and the citizenship, so they have an understanding of which search engine results that might affect.
I just want to make a comment at this point. I constantly repeat, send them everything. Don't ever just send a little bit, send all your evidence each time, because what will show up very quickly is what they haven't read. For instance, we just dealt with the Australian Press Council, which I'll tell you a little bit about tomorrow. And we were starting to get questions from them where they were asking us things for evidence that we had already sent them. And it started to indicate to us very quickly that they weren't reading it, and what they were doing was stalwart. They thought they were asking us a question that we didn't have evidence on or couldn't find or we would waste time looking for. So we could constantly go, but you already have it. We sent it at such and such a date, but just for your own benefit now, we will resend it to you. And we will make sure they got that within 24 hours or 48 hours. So be aware that that's also the game. If you send them everything, you will quickly learn if they're looking at the evidence or not. All right? And I think this is what you mean as well.
Yeah. And with that, with the Australian Press Council, because they've now been passed up probably 3 levels within the Australian Press Council, and that's happened 3 times now when we're replying it saying, well, we gave it to you, the evidence to you on a USB, we mailed it. I've emailed it to you on this date to this person, I've emailed it to this person on this person. So here you go, here it is again, but this is what we've already done. And it's getting to that point.
Yeah, so now we're building a case against the Australian Press Council to show that we're in a buck-passing situation again, okay? All right, because the people that we're targeting are so high up in the country now, yeah, that nobody wants to touch it. So whichever case manager has got it has a hot potato, okay? So, and this occurred with the Ombudsman offices as well. The Ombudsman office did this, and we saw this occur with Queensland, with the Queensland board. So you will, if you see that starting to happen, it just gives you a trail so that later on, if you have a finding that is not appropriate, yep, you can go public with it on the internet to show what was going on. Yep, to show, well, in the end we got that result, but really this is what was going on the whole way along. So you need to keep building your safety net.
And now that's sitting with the director at the Australian Press Council. It's the person sitting. So on to the next slide.
Yep.
This is I was talking about in Europe. It's a little bit they're a little bit more fortunate over there with some of the things that have happened recently legally. So there's a concept over in Europe and in Argentina about this right to be forgotten. And it's not necessarily just to do with the internet, but it's also in the laws as well. So it's all about the desires of individuals to determine the development of their life in an autonomous way without being perpetually or periodically stigmatized as a consequence of a specific action performed in the past. So the notion of the right to be forgotten is derived from numerous pre-existing European ideals. For example, in the United Kingdom, specifically under the Rehabilitation of Offenders Act, after a certain period of time, many criminal convictions are spent, meaning that information regarding this person should not be regarded when obtaining insurance or seeking employment. Similarly, in France, they have a concept called the right to oblivion, which has been recognised in French law in 2000. So in 2010, this is where it started to come across into, concept started to come across into the internet, Google. The European Court of Justice legally solidified the right to be forgotten as a human right when they ruled against Google in the Castella case. So a Spanish man requested the removal of a link to a digitised 1998 article in a newspaper about an auction for his foreclosed home for a debt that he had subsequently paid, and he was successful in getting that removed. So in the first few days after the ruling, thousands of Europeans asked Google to take down links with approximately half pertaining to criminal convictions. That's where a lot of people are nervous about this ruling because there's some criminal convictions that people don't think should be removed. So you have an understanding.
Wasn't it in the 15 minutes after the finding came? I think something like 12,000 requests were put to Google in 15 minutes.
They said it was in the first 24 hours, but maybe it was
15 minutes.
Yeah. And then 70,000 requests over the next 8 weeks.
So sorry, this jurisdiction extends where?
To Europe. Just
anything that belongs to the EU.
Right? And in America, the Americans went crazy for this. Yeah, and Google has been inundated in America. And our legal representative, Christopher, called out as Bruce was, as soon as this hit, it hit that minute, 5 minutes later, we had an email from him going, let's do it. And which is ridiculous. Why do I have to do it? I haven't done anything wrong. But his view is, let's make the request. And that means it's gone. It means everything is gone. Though anything with your name in it will come down off Google, good, bad, or indifferent. You are forgotten off the system. Okay, so basically, it's demanding the right to have a silent presence. Like you have a silent telephone number, or you have a silent address. You're voting, your ballot voting through silent. You're a silent voter. The right that your address and your phone number is not known, you are saying, for my own reasons, I wish to be silent. Do not put my name on any search engine.
There's so many other engines like that now. There's a lot of engines up now where they know everything. The address worse than Google. Yeah.
But I'm sorry, I'm not getting this, because if that's an EU thing, how can us based in Australia access that?
Well, what's basically happening now is en masse people in Australia and in the US are requesting the Google US and Google Australia to do that for them as well.
Okay.
And they're giving evidence as to why. Now, it's only a matter of time before somebody takes legal action.
Yeah.
Whether Google is going to want that, and basically Google is in the process now, they say they're sifting through them, deciding who and who can't be removed.
Yeah.
It's a high court ruling in Germany.
Yeah, it was Germany.
Caused this to happen.
Yeah, this is what we're
It
doing.
caused Google.
The problem is that people are saying, well, why should Google now be the one that decides whether the information stays up there or not about someone? They're starting to become almost a legal system deciding, say, like a pedophile as information or something, and people still want that up there and available. And does Google become the organisation that decides whether that should stay up there or not?
So they're saying that Google start being quite powerful to make these decisions.
But I thought that was removed from Google by the High Court decision is saying Google, you must take that down if that person requests.
Yeah, but only in Europe at this point in time. Okay. Next one.
It was just the last point. Just it did point out, despite what you're saying about the US, that there is a lot less chances of like a right to be forgotten in the US because of the right to free speech, according to the First Amendment, and the right to know. They basically making it more difficult for that information to be removed in the US. So that's probably why everyone in the US jumped on this when it happened in the EU, hoping that they might be able to get things removed.
So so innocent parties that have been defamed now have to spend the time to have that removed. But from my perspective, I believe people have the right to be a private individual. If we don't want people to know who we are, where we live, what we're doing, I mean, to the point, it's going to be the last slide for today. Yeah. So what I'm going to do, this is going to be the last slide for today, and I'll take the rest of this because I want to stop it right at the point of all the legal information, because tomorrow Chris is going to talk to you about how to go onto the internet, create web pages, how to set up different areas so that your name can go up on a positive tact. So, for instance, within the social media now, I'm known as a clinical psychologist versus being a cult leader now. So what we're doing now is we're going through a process of bringing up this other information, and I object to the fact that I have to do it.
Does that mean you've been demoted?
I've been demoted. My one and only cult member who said I was a bad cult leader left me, and now I'm demoting myself. Now, it's just ludicrous. You don't understand. Sometimes I just stand there and it's just ludicrous. A highly intelligent, normal human being that's quite well educated has just got caught up in this crazy world where those people that I would assume would be of a higher standing than me in society behave like an absolute rabble. And I mean, that's all that I've seen is just a rabble of ridiculousness. That blows the concept of the more you're highly educated, the more emotionally intelligent you are right out the door. Where I'm going with this is that now what we have to do is we have to create a new persona that comes in and pulls the other one down. My preference would be to become anonymous and a private citizen. And the reason why we're doing that is that in the throes of all of this, they even put down my home address, where I lived, Google Maps of how to get to my home, with views of my home, and I mean, right down to how to go up my driveway and what to do. Like the level of invasion into my life was something unbelievable. Okay, to the point where we can't live in our family home. You know, we just can't live there. How can we? And we don't know who is going to read that. The problem is this type of thing that has just occurred to our family is who now is going to pick that up? What deluded person or somebody with a severe mental health issue that may be in a worse state than the ones that I'm already dealing with can now pick this up and run with it? And then all of a sudden I have got what I would consider a completely radical human being after me that I don't even know is after us now. See? So this is the problem. The type of things that they have done can ignite anything. And you know, within our own industry and the cohorts that we work with, we know that there are people out there that are psychopathic enough that they will just take this up and run. And this is an issue. It's very dangerous what the internet can do. It is an incredibly dangerous tool, which was supposed to be sharing information, and it's gone crazy. So yeah, at the end of the day, I think at the end of the day, the internet will end up being heavily policed, and there will eventually be groups and squads that will be dealing with policing this. But nobody's got the time or the money or the energy currently. So on goes the problem. This tomorrow we'll go through the process of breaking down what you can do. Yeah, so that even if there's a small snippet of negativity out there, what can happen, how to undo it. Secondly, how to put an internet safety net into place now in case something happens in the future, so as that you don't end up in as an exposed position as what I was.